dat Joshlin wel gevind sal word, ongeag ons onbeantwoorde vrae.
Before Ms. Polani proceeds, this document was signed by Ms. Mom.
It was signed.
And I understand that there were two items that you received from the school. My lord, those would be additional that will form part of the record. I think we should move on to 6.
That will be 6.
Indeed. I have handed the original to the court.
Because I need to.
I'm going to ask the investigating officer to put both.
Looks like fingerprints
Correct.
that indicate the leaves of the tree, and I'll have it as explained.
Indeed, thank you.
It's not to identify the
Certainly.
They use a calendar charge with a picture of Joshlin Smith on it. The name is spelled wrong, but that's fine. On the printed version, it's currently on the screen. It says, Joshlin, ons bid dat jy veilig sal terugkeer. And then in pencil, in another block, reading the Afrikaans, and I'm sure it will be interpreted soon. Liewe Joshlin, ek en die ander maats verlang vreeslik na jou. Ons bid dat jy veilig is en gou na ons sal terugkom. Jou maatjies by Deelsville Primair.
There is where Joshlin Smith's name is, but the name is spelled wrong, but that doesn't matter. Sorry, my lord, I just need to.
Ms. Bolton, could you please explain before Ms. Polani goes through the smart statement, what are the pictures before court and how were they obtained?
Yes. Hierdie foto is 'n foto wat die woorde, dis die boodskap is 'n boodskap wat deurgegee was deur Joshlin se beste vriendin op skool. Sy het dit aan juffrou Edna Maar deurgegee en ook so neergeskryf en sy het dit aangegee aan die slagoffer impak verklaar.
What is standing here on this picture, my lord, it's where that was written by Joshlin Smith's best friend, of which she wrote it out and she gave that to Miss Mott, and hence it is attached to the document.
And the second image that's up, can you explain what that is?
Die tweede image, dis 'n boom. Dis die boom van hoop. Die vingerprinte wat daar opgedruk is die klasmaats van Joshlin Smith.
The picture that is depicted there, my lord, it's a tree of hope, and the fingerprints that are on there, those fingerprints are from Joshlin Smith as classmates.
Dit is klasmaatjies sowel as ander maatjies van daar. As u kyk, daar's een takkie wat nie 'n fingerprint aan het.
My lord, if you can look there is also from her classmates and her other friends, but you will see there's one branch that does not have a fingerprint.
En dit simboliseer die leemte wat hulle voel
It symbolizes the void that they are feeling
in die klaskamer,
in the classroom,
sowel as die hoop dat Joshlin wel eendag sal belle aansluit.
with the hope that one day Joshlin will come back to them or will join them.
So it's visible on the picture, the second branch from the bottom on the left, as one looks at the tree.
That is correct, my lord. Ms. Polani, you may proceed. Thank you.
Sorry, my lord. The victim's statement that is going to be read now, it is of Mrs. Tahir Edna Mott. As an educator, I thought and also hoped that someone will play a prank on Joslin's mother. But the second day, I realized it was not a prank. We as a school community, we were suddenly immersed in a situation we have never experienced or known before. As an educator, I then realized that I had to put myself aside to calm my learners every day, because every day was the same question for me, asked, Miss, when is Joshlin coming? Every day I also discovered confusion, fear, and also hope in their children's faces. As an educator, mother, and a grandmother, I sometimes had to go deep within my humanity, scratch around and about to accommodate everyone entrusted to me, because learning had to take place in these unknown and unforeseen and traumatic circumstances. What I also realized at that time was that this event could have a long life traumatic impact, not on me, but on every learner, and yet they need to be protected at all times. Most of our learners were in tears every day, especially the friends who were very close to Joshlin. Parents were very protective and out of fear, of course. During that period, parents came more than before to bring their children away and pick them up at our school's gate. Through the emotions that the child experienced, the learners mentioned to me that Joshlin's song was God Will Work It Out. With that said, we as a class together decided to start our day with a song. Never will I want any of my colleagues to be affected by such trauma. Daily, I thank our Lord Father that I still stand strong for every learner and for Joshlin. The images of my learners' faces, the confusion, anxiety, and also hope I'll never be able to erase from my memory. I would like to know, how do you answer a child who is looking for answers that you are looking for yourself? From Joshlin's disappearance and until now, we as a school community still uncertain because no one knows what to expect. The Western Cape Department of Education also supported us and still does. Our school social worker, Mrs. Sonia Luaks, also visited learners regularly to provide the necessary support services to them as well as to us as the teachers. Joshlin is still on our system at school and will stay there because the hope that she will be found, with the hope that she will still be found. With the hope that she will still be found, my Lord. I salute our principal, Mrs. L. Davis Hartenberg, for the way she has carried the school community. She also made sure in a professional manner with her team that we function well as a school and still strive to give our best every day. Looking back now, I will say that we will always have the hope that Joshlin. Sorry, Marlo, can I just go back? Looking back now, I will still say that we will always have that hope that Joshlin will need to be found regardless of our answered questions. This was dated on the 12th of May 2025. And also, my Lord, there was also a picture that was placed up. Joshlin, we pray that you come back safe. Joshlin, myself and the other friends also wish. Sorry, my Lord, it was myself and the other friends miss you so much. We pray that you will come back safe and sound to us, safe and sound. Your friends by Deersville Primary, that was placed up before. Yes, my Lord. Yes, my Lord.
Block on the picture.
Thank you, my Lord. Ms. Bolton, the third victim impact report is a poem, is that correct?
Dis korrek, edele.
Yes, my lord, and the third victim impact statement, it is a poem.
VV3, my lord. VV3.
That's VV3. That's it's a handwritten document. The original is in blue. On a piece of paper. It looks like a poem.
Please proceed, Ms. Bolton.
Die slagoffer impakverklaring is geskryf deur Taylor Andrews, gedateer 19 Mei 2025 en ook geteken deur Taylor Andrews.
I take it she's the daughter of Natasha.
Dis korrek, edele.
Yes, my lord, she is the daughter of Ms. Natasha Andrews, and her victim impact statement is dated the 19th of May 2025.
And I see on page 4 she's currently 14 years old.
Dis korrek, edele.
Yes, that's correct, my lord.
Yes, thank you.
Ms. Bolton, may I please ask that you speak up a little bit? I think this is when we're going to be completing with the webinar.
Maak so.
I will do so.
'n Gedig aan my suster. So, waar begin ek? Ek mis jou lekker lag, tog so stil en sag. Dit het al my probleme gedek. Jou verdwyning het my soveel pyn gebring. Dit is so hartseer. My hart is so seer dat dit voel soos doringring. Ek is so vol gedagtes en vra. Wie gaan dit antwoord? Is ek nogal mee gepla. Joshlin, waar is jy? Antwoord my. Kom asseblief terug, sodat jy my pyn kan verlig. Jy verdwyn soos mis voor die son. Wie weet wanneer ek jou weer gaan sien. Ek mis jou, so baie. My hart voel soos leelaaie. Jy het so gauw weggeraak. Wat het dan met jou gemaak? Ek hoop jy's veilig, daar waar jy is. Maar God se seën op jou rus.
This is a poem for my sister. Wow, where do I start? I miss your good love, so quietly and soft, that covered all my problems. Your disappearance have brought me so much pain. It's so sad. My heart is sore, that it feels like a thorn ring. I'm also full of thoughts and questions. Who is going to answer that I'm quite bothered with? Joshlin, where are you? Answer me. Please come back, so that you can ease my pain. You have disappeared like a mist in front of the sun. Who knows when I will see you again? I miss you so much. My heart feels like an empty drawers. You have gone so soon. What did they do to you? I hope you are safe where you are. May God's blessings rest upon you.
Thank you. That was VV3.
Support, please. VV4, Ms. Bolton, is the victim impact statement.
Yes.
Can you tell us who it's from?
Die vierde slagoffer impakverklaring is vanaf mevrou Amanda Daniels, wie die biologiese ma van May Smith is. Dit is gedateer 26 Mei 2025. Dit is ook geteken deur mevrou Daniels.
I also note it was written on folios. Just for the record, it's written on both sides of the paper, so
Yes.
copies are made. That we don't miss. The pages are numbered 1 through to 4.
Confirm that, my lord. You may proceed, Ms. Faulkner.
Witness still going through the documents, my lord.
You can just read the handwritten note, because that's the comment.
Ten so edele. Kelly, jy het ons lewens kom jou op aarde maak. Jy het ons kom breek en uit mekaar kom skeer. Weet jy wat dit is om elke nag wakker te lê en huil? Dit voel my hart word uit my liggaam geruk, want ek bid vir Joshlin. Ek bid vir haar veiligheid. Ek bid dat God haar moet bewaar waar sy is. My kussing is deurtrek met trane oor jou dade. Weet jy hoe dit elke môre voel as ek my kleinkinders moet wakker maak vir die skool? Dit rus swaar op my hart, want dit voel ek moet heeldag by hul skole wees om hulle op te pas. Want net dalk gebeur daar iets met hulle. As jy net eendag in my skoene kon staan, om op die horlosie te kyk en te sien, maar Ricoen is 2 minute na sy gewone huis toe kom tyd, nog nie by die hek nie. En gaan staan soos 'n besetene buite in die straat, en begin die pad aanvat, om te gaan kyk waar hy is. As hy moet rugby gaan oefen, of enige skoolfunksie bywoon, rus ek nie voor hy aan die deur klop nie. Ek moet nagte opstaan en hom gaan toemaak as hy hom oopskop, want hy is nie daar om dit te doen nie. Hoe dink jy moes ek voel om vir Rachel by my te hê vir die vakansie en haar kroonverjaarsdag? In die nag as ek opstaan om toilet te gebruik het sy opgevlieg met armpies uitgestrek en vra, "Mami, waartoe gaan jy?" Ek moes haar telke male optel en saam na badkamer toe, want sy is bang ek los haar alleen. Dit het my elke keer gebreek as sy speel en net skielik vir my kom sê, "Mami, weet jy my suster is weg en my ma ook." Hoe het jou hart gevoel Moedersdag? Ek het my oë uitgehuil toe my kleinkinders my kom verras met ontbyt in die bed. En Ricoen vir my 'n gelukkige Moedersdag toewens. Het jy nie gewens jy kon jou 3 kinders by jou hê nie? Ek is die een wat saam met Ricoen kniel en bid. Ek moet hom help met sy skoolwerk en by die tafel sit dat hy moet lees. Ons persoonlike lewens as familie het jy soos vuil wasgoed probeer was deur jou dade. Ek as jou biologiese ma het jou laat aanneem van my ouers, omdat ek jonk en onkundig was. Ek kon nie by die huis sit en verwag my ma, wat 'n onderwyseres was, en my pa, wat 'n ambagsman was, moet vir my onderhou nie. Ek het jou aan hulle gegee, omdat ek gaan werk soek het, en omdat ek geweet het, hulle sal jou die beste in die lewe sal gee. En dit het hulle gedoen. Van ons kant af, het ons jou elke keer gaan haal met Ricoen, en later toe Joshlin ook gebore is, het ons jou gaan haal, om by ons te bly, maar jy het elke keer in ons gesigte teruggegooi.
Elke keer in ons gesigte teruggegooi.
Yes, ja.
En die jare bysvriend.
Ja. En teruggegaan Saldanha toe. Ek wil vir Ricoen aanneem en jou woorde aan my was, dan wys ek jou, ek maak weer 'n kind. Ek kan na Rasan se graf toe gaan en my hart gaan uithuil, want my kind was siek en het in die hospitaal gesterf. Waarheen gaan ek as ek huil oor Joshlin? Ek moet net op my knieë gaan en bid en huil. Dink jy daaraan hoe die Andrews familie voel wat die beste vir Joshlin in die lewe wou hê? Jy wil nie verantwoordelikheid vat vir jou dade nie. Nou wil jy die victim speel. Jy het my in my gesig gekyk en gesê, Mami, ek sal praat met ons volgende voorkom. Ek het jou geglo want jy het gesê, jou prokureur het gesê, hy sal praat. Maar nou sal jy praat na ek by jou gepleit het. Maar weer eens, leens. Hoe slaap jy? Hoe lewe jy met jouself? Jou broers en susters is al waar hulle werk, maar ek slaap nie saans, voor ek weet hulle is veilig by hul blyplekke nie. Dit is wat 'n ma is. Ek as ma sal my altyd bekommer oor my kinders en kleinkinders, en ek sal nooit rus voordat Joshlin nie gevind is nie. Dink jy nie hoe seer Rico kry as kinders hom spot oor sy ma wat tik en sy bloedsuster verkoop het? Ek moes al my kleinkind by die skool, ek moes al my kleinkind gaan haal by die skool deur jou wrededade. Deur jou wrededade word dit lelike dinge gesê. Op so 'n jong ouderdom moet hy al leer hoe om homself teen die wrede wêreld te verdedig. En dit deur jou toe doen. Laastens wil ek hê jy moet weet Joshlin sou die hele liefde en aandag gekry het by die Andrews familie. Hulle sou die beste ouers vir haar gewees het. Nou sit hulle ook met die groot seer, dit alles deur jou.
My Lord, sorry. The fourth VIS, my Lord, is from Miss Amanda Daniels, Amanda Smith Daniels, being the mother of Miss Kelly Smith, dated the 26th of May. Dated the 26th of May 2025. Kelly, you have come and make our lives hell on earth. You came to break us and tore us apart. Do you know what it feels like to lie awake every night? How it feels like my heart is ripped out of my body because I pray for Joshlin. I pray for her safety. I pray that God will keep her safe where she is. My pillow is riddled with tears over your actions. Do you know how it feels every morning when I have to wake up my grandchildren for school? It weighs heavily on my heart because it feels like I have to be at their school all day to look after them because maybe something will happen to them. If you can only stand in my shoes for one day, look at the clock and see. But Requin is 2 minutes to his usual time to come home. Does not arrive at the gate. Time does not arrive at the gate, and I stand like a crazy person out in the street. Start to taking the road to see where he is. If he has to go to practice or to attend any school functions, I don't rest before he knocks on the door. I have to get up at night and go close him if he kicks him open. Kicks himself open. You are not here to do that. How do you think I should feel about having Rochelle with me for the school holidays and her crown birthday? At night when I when I got up to use the toilet, she flew up with her arms stretched out. Sorry, my Lord. When I got up and to use the toilet, she flew up with her arms stretched out and asked, "Mommy, where are you going?" Where are you going? I had to pick up again and again and carry her to the bedroom because she was afraid I would leave her alone. It broke me every time she played, and suddenly she came to me saying, "Mommy, knows my sister is gone and my mom too. How do you feel? How does your heart feel on Mother's Day?" I cried my eyes out when my grandchildren came to surprise me with breakfast in bed, and Requin wished me a happy Mother's Day. Did you not wish you could have been with your 3 children with you? I'm the one that kneels and prays with Requin in the evening. I have to help him with his schoolwork and sit at the table for him to read. Our personal lives as family, you try to wash as dirty laundry to your actions. I, as your biological mother, made you to be adopted. Sorry, my lord. I, as your biological mother, made you to be adopted by my parents because I was young and innocent. I could not sit at home, expect my mother, who was a teacher, and my father, who is a artisan, sorry, my lord, who is a artisan or a bricklayer, had to support me. I gave you to them because went looking for a job because I knew they will give you the best in life, and they did. From our side, we have to pick you up with Requin, and later when Joshlin was also born, and when to take you or pick you up to come and stay with us. But each and every time you threw that back in our faces and went back to Saldanha. I wanted to adopt Requin, and your words to me was, "I will show you, I will make another child again." I can go to Richard's grave and cry my heart out because my child was sick and died in hospital. Where do I go when I cry over Joshlin? I just have to go on my knees and pray and cry. At least do you think how does the Andrews family felt who wanted the best for Joshlin in life? You don't want to take responsibility for your actions. Now you want to play victim. You looked at me in the face and said, "Mommy, I will talk the next time when we appear." I believed you because you said, your lawyer said, she will speak or he will speak. Sorry, my lord. But now you will speak after I've pleaded with you. But you lied again. How do you sleep? How do you live with yourself? Your brothers and sisters are already where they work, but I don't sleep at night until I'm home safe at their places to stay. That's what the mother is. I'm also a mother, always worried about my children and my grandchildren. I will rest nicely before if Joshlin. No, I will not rest nicely before Joshlin is not found. Do you think how hurt Requin gets when kids stop him? Sorry, my lord. When kids make fun of him about his mother using tick and selling his blood sister. I had to pick up all my grandchildren from school. By your cruel act, ugly things said to him. At a young age, he already had to learn to defend himself against the cruel world. Through your doings. Lastly, I want you to know Joshlin would have gotten all the love and attention from the Andrews family. They will have been the best parents to her. They will have been the best parents to her, and now they are also left with great hurt. All this because by you. Amanda Smith Daniels, dated the 26th of May 2025.
Thank you, Ms. Bolton. The fifth attachment to your report is the victim impact report by one Natasha Andrews. My lord, VV5. Thank you. If you could proceed to the body of that document, Ms. Altman.
Maak so edele. Die slagoffer impakverklaring gedateer 15 Mei 2025, ook geteken deur mevrou Natasha Andrews, lees as volg. Hoe verduidelik en skryf 'n mens 'n gebroke gesin met gebroke harte? Die leemte, die seer, sjoe. Waar begin 'n mens? Ons missie is so baie. Die wakker lê en rondrol, vrese en verlange. Want het jy 'n bedjie om in te slaap en word jy versorg? Die wonder of jy na ons roep, jou mammy, jou broer of sustertjie. Ekskuus. Die wonder of jy na ons, jou mammy, broer of sustertjie roep. Joshlin, jy vul ons gesin in so baie maniere, want jy is deel van een gesin wat jou so baie liefhet. Die seer van jou verdwyning lê baie diep. Dis 'n groot leemte, onbeskryflik. Niks is meer dieselfde nie. Ons weet nie hoe om aan te gaan nie. Ons probeer soms, maar dan slaan die werklikheid weer. Ons mis jou gelag, geselsies, rondhardloop in en om die huis. Jou sagte drukkies, jou hare te kam, om jou te leer skryf en tel. Jy en Taylor se swem in die badkamer saans en die gelag wat weer klink vanaf die badkamer. Ons mis jou gevra heeldag na 'n bietjie water. Kry jy water waar jy is? Ons mis jou fyn, sagte stemmetjie wanneer jy geroep het by die hek, wanneer jou mamma jou gebring het. Self jou opgehelderde gesiggie met 'n breë glimlag wanneer ons jou by julle huis gaan haal het. Julle twee meisies is saam gaan klere koop. Taylor het nog nie weer, maar ek moes maar namens haar gaan, al breek dit my mamma hart. Joshlin, ons het so uitgesien na jou volgende mylpaal, jou tande wissel. Want jy het altyd na skool kom noem van 'n maatjie wie se tande los was, of al uitgeval het. Dan wikkel jy aan jou eie tandjies, maar dit was nog nie los nie. Jy was die hele winter van 2023 by ons, en van ons af skool toe gegaan. As ons die deur oopmaak op pad skool toe, dan sê jy, dis dan nog aand. So donker dit was. Ai Joshlin, jou wegsteek in die huis, as jy die hek hoor oopgaan, want Anke Lionel is terug vanaf die werk, en hy moes jou soek. Jou kom na my, want ek moes jou seerplek soen. Jou uitsien na verjaarsdag of daar. En kom sê, Matassa, my koekebak. Matassa mis dit om na jou om te sien wanneer jy siek was. Jou toeneus en benoude bors het my altyd so bekommerd. Is jy warm genoeg waar jy is? 2024 was jou eerste verjaarsdag wat ons jou nie kon sien. Ons harte was buite ons bors van seer. Hoe eindig 'n mens hierdie verklaring? Met jou hart buite jou bors van seer. Trane wat vlak lê en onsekerheid van elke dag. Ons wil jou net graag weer drukkies gee. Jou stem hoor en jou in ons midde hê. Joshlin, jy is ons blomblom, ons baba dogter en groen oogkind. Om na jou fotos, voice notes en video's te kyk en te luister, hou ons gemotiveerd. He left the 99 sheep to find me. Luke 15 verse 4 till 6. Daar is so baie wat nie weet hoe Joshlin klink as hy lag of praat nie. So die volgende foto's, video's leg ek aan sodat die wêreld ook haar stem en lag kan hoor en ook haar persoonlikheid soos uitgebeeld in die foto's. 'n Persoonlikheid waarna ons so baie verlang.
Let's first do the demonstration and then we can play the video. I think it will be on the screen.
The victim impact report of Ms. Natasha Andrews dated the 15th of May 2025. How does one explain and write about a broken family with broken hearts? The void, the hurt, wow. Where does one start? We miss you so much. The awake lies and to lie awake and roll around. Fears and longings. For do you have two cots to sleep in? Sorry, my Lord. Do you have a bed to sleep in? And are you being taken care of? Wondering if you're still calling out to us, your mommy, brother, and sister. Joshlin, you fill out our family in so many ways because you are part of one family that loves you so much. The hurt of your disappearance lies very, very deep. It's huge, void, indescribable. Nothing's the same anymore. How do one know how to go on? We sometimes try, but then reality strikes again. We miss your laughter, chat, running around, in and around the house. Your soft hugs, combing your hair, teaching you how to read and count. You and Tyler swimming in the bathroom at night. The laughter that echoes from the bathroom. We miss you asking all day for little water. Do you get where you are? We miss your fine little voice when you call out at the gate, when your mom brought you. Even your brightened little face with a broad smile when we went to pick you up from you or from your place. You two girls will go shopping for clothing together. Tyler has not gone again. I just had to go on her behalf, even though it breaks mommy's heart. Joshlin, one was looking forward to your next milestone, your tooth change, because you always come home from school to mention that a little girl's tooth that has gone loose. Sorry, my Lord, because you always come home from school to mention that a little girl who lost his tooth or the tooth is loose. And the tooth has already fallen out. Sorry, my Lord, the tooth has already fallen out. Then you will loosen your tooth, but your tooth was not loose yet. You have been with us and gone to school from us all winter of 2023. When we open the door on the way to school, you will say, it is then still evening, as dark as it was still. Joshlin, your highs in the house when you hear the gate open, because Uncle Lionel is back from work and he had to look for you. You'll come to me because I had to kiss your sore spots. We look forward to your birthdays, and you come to say, Mommy, bake cakes for me, bakes my cakes. Mom Natasha miss taking care of you when you've been sick. Your stuffy nose and distressed chest have always made me so worried. Are you warm enough where you are? 2024 was the first birthday that we cannot see you. Our hearts were beside our chest. Our hearts were beside our chest. Our hearts were beside our chest with hurt. How does one end this impact report? How does one end this impact statement? With your heart outside, your chest out of hurt. Tears that lies shallow in uncertainty of each day.
Shall we?
No, it's fine, my lord. We just have to argue again your voice, to hear your voice, and have mist in our heart, in our midst. Joshlin, you're our flower, our baby daughter, our green-eyed child.
If you want us to take a break, we can do it.
It's fine, my lord.
Will you be fine?
Oh, fine. Watching and listening to your photos, voice notes, and videos keeping us motivated. He left the 99th sheep to find me. Luke 15, verses 4 to 6. There are so many people, there are so many who don't know what Joshlin sounds like when she's laughing or talking. So the following photos and videos I attach so that the world can hear her voice and her laughter as well, and also her personality as depicted in the photos, in the personality that belongs so much. That is a victim impact statement of Ms. Natasha Andrews, dated the 15th of May 2025.
Thank you, my lord. I'm not sure if you want to take a small break or if I can proceed with the video.
We won't need, let me just see it. Shall we take a break?
That was fine, my lord.
So we're going to play the video
Then take a break.
and then take a break before the, if there's any cross-examination. Because immediately after that, I will be going into argument.
Certainly.
I've noticed, Mr. Sivnarai, I was addressing the interpreter because the interpreter is emotional.
Yes, my lord.
It's difficult for, I think, most of us that have human feelings or should have in this courtroom. So let's bite the bullet now. Let's listen to the video, and then we're going to ask whether there are any questions. If there's none, we'll then take the break. Something we have to go through. I can understand that it's emotional. I can see a lot of teary eyes from where I sit. So remember, everybody's facing me. Let's play the video.
Thank you, my lord.
Thank you.
My lord, I'm going to ask you to be seated so I don't block the media. May I ask you to be seated so I don't block the media behind you?
Certainly.
It's not a long video.
Certainly. I don't know what it is because it wasn't attached.
It isn't long.
If you want to move away so that you can see better. It will be uploaded, I take it, to the Teams where it will be a much better picture.
Certainly. My lord, I know there's audio to this.
I'm going to take a 15-minute break. When we're going to come back, I've noticed that Smith is sobbing loudly, so we'll give it an opportunity. I think 15 minutes will be sufficient. It's now 9:50. a slightly longer time. We will come back. You excuse till then. I'm not sure whether there will be questions. There may be, so just be at standby to the witness.
All right.
know that you're part of a team sitting over there. You may take your seat.
Thank you, my lord.
Yes, Mr. Harms. That's all the evidence, I take it.
Indeed, that is correct, my lord. That is all the evidence for the state.
Thank you.
My lord, may I please ask that we swap around? Ms. Swanepoel will be dealing with the arguments.
Certainly. I'm going to start immediately with Mr. Harms. Then we're going to go through the defense, and then the state will have the opportunity.
Certainly, thank you.
Yes, thank you, Mr. Harms. Thank you.
May it please the court, my lord. I think it's on record as well already that accused one will not be giving evidence on the mitigation of sentence.
But having said that, it's customary that submissions and information, insofar as it relates to evidence, can be placed on record from the bar.
Indeed, my lord, yes.
And I was contemplating that question last night in the event that the witness on behalf of Mr. Van Rijn might not be available, that Mr. Kabay can place the information on record from the bar, whatever further information
Indeed,
is placed. As you know, it's customary that the three options are given, and it happens every day. I was going to refer to an old story of the Cape High Court, referring to a former colleague of mine, but then I realized that the colleague might still be alive. The colleague would be 98 years old now, and he turned 99 on my birthday because we share a birthday. And it was also the day that Shubi was delivered, on that day. So I decided not to tell the story.
I take note, my lord.
But I think you know the story.
Yes, my lord, I am aware of that, yes, my lord.
Yes.
Thank you, my lord. I'd like to start off with accused one's personal circumstances. I have, in the circumstances, much less to say on the court having been placed in possession of Exhibit SS. I have looked at the details as far as the personal circumstances of accused one, or let me refer to Mr. Pollis. Mr. Pollis's personal details, his age, where he comes from, his family, his brothers and sisters and children, it's all in front of the court. With the leave of the court, I'm not going to repeat all that.
It's on record, and I've taken note of it.
Yes, and may I then, just for the sake of completeness, then refer to what was referred to when Mr. Peterson gave evidence that there are one or two inconsistencies, but the court is well aware of the evidence that was laid in this matter, and it is, as your lordship had said, of no moment, the aspect around Joshlin, whether she was at school or not at school, and what my Mr. Paulus would have said to Mr. Peterson or not. I agree that it's not going to make, in the circumstances, any difference to argue that he isn't or wasn't lying to Mr. Peterson. That I'm not going to argue.
Is the question not that it relates more to count one? Because of the existence of the prescribed sentence, that I need to focus, and yes, I need to focus on it holistically. Was it you that referred me to Malchus?
No, my lord.
I've got a number of cases open here. I've got...
The state referred your lordship to Malchus. I didn't because they did.
Yeah. So we need to look at substantial and compelling circumstances.
Yes, indeed.
And yes, we need to look at it holistically. It's not nitpicking one here or the other, but there's also the authorities from the Supreme Court of Appeal, and I've been referred to a case, whether it's on point or not, that I'll debate with Mr. Kabai from the Constitutional Court, where it's also dealt with. And the question is, how do I approach the substantial and compelling circumstances, and how do I weigh that with the general principles? I see people are still referring me to Zin and Rabi, and we can debate that. In coming to a sentence that is just, it's coincidentally also a term used by Mr. Peterson in his evidence yesterday, because that's the bottom line here. What is fair and just, having regard to, if one wants to refer to the triad, if we want to refer to the element of mercy, a la Rabi, depending on how you interpret Rabi, because the textbooks seem to only refer to the one of the judgments, whilst we know, I don't know whether people know that there were actually 3 judgments in that case, and nobody ever refers to the facts of that case, because the facts are very peculiar. And it's not necessarily set out in the judgment that's often referred to, because I get referred to the judgment of Corbett, that last paragraph, the Corbett J.A. as he then was, and ignore the judgments of Kotze A.J.A. and Holmes J.A. as they then were at the time. That's a 1975 judgment.
Yes, my lord.
So I don't want to unnecessarily stop you in your tracks, but if you can address me on having regard to the personal circumstances, the circumstances of the offence itself, circumstances that prevailed in which the accused had operated at the time, seriousness of the offence, the interest of society, the purposes of sentence, coupled with that all of this is infused with a measure of mercy, and that I must bear in mind that I'm not here to take revenge. It must be balanced. It must be focused on the individuals, human beings that are being sentenced before me, having regard to all these other factors.
Thank you, my lord. Yes, my lord, if I may, because I find it very important and it should actually be argued at the end, I want to open with it and hopefully I'll remember at the end.
Can I just ask that there may be just a microphone for you? You're competing with the wind and the shutters in the roof. And I'm not sure whether people are able to hear you properly.
My Lord, yes, what I did refer your Lordship to, and I see my learned colleague for the state has also done that, was the matter of state versus Habib.
Yeah, that's the judgment of Kurtse.
Kurtse AJ. Kurtse CJ AJ, yes, my Lord.
Yeah,
CJ, I don't know why they put that there, my Lord.
I don't know why it's cited like that, but it is so.
Maybe they have another Kurtse there, my Lord.
We used to do that in the Cape, because we had more than one Erasmus.
Yes, my Lord. And then I also referred your Lordship to the state versus Edward Ayuk, which is the Western Cape High Court
Is that the judgment of
the VED.
Of the VED
AJ, yes, my Lord. Yes.
I've read both cases, and I have an opinion.
I'm sure your Lordship will. I'm not going to submit that there anything prescriptive in there. It is, as far as the big matter is concerned, I liked, if I can use that word, the method that CJ, acting judge, used in that matter.
Yeah, I'm with you.
What I wanted to mention at the outset, my Lord, is the Prevention of Combating and Trafficking in Persons Act, Section 13. So I know I'm starting at the back now, my Lord, but I just want to place that before your Lordship, first of all, and I'm just going to read paragraph 13A, where it says Section 4.1 is subject to Section 51 of the Criminal Law Amendment Act 1997, in brackets Act number 105 of 1997, liable to a fine not exceeding 100 million or imprisonment, and then comma, including imprisonment for life, comma, or such imprisonment without the option of a fine. Now, what I would like to argue at the end is that how I see it respectfully, with humility, humbly will argue that maybe that has some significance, the fact that it says including imprisonment for life.
Yes.
I'm in agreement with my learned colleagues for the state that, which has been said before, that this is a unique case. This matter that we are seized with is a unique case in the sense that the victim is not here. We do not know where the victim, Joshlin, is, or what happened to Joshlin. So the court had to rely on all the witnesses, the evidence that was placed before this court. And yes, indeed, the court has found Mr. Apollos guilty in terms of Section 4.1 in count 1, and then obviously count 2, kidnapping. Now, the difficulty that I submit we're sitting with is that we don't have before the court any explanation as to what happened on the 19th of February 2024. We only have the evidence that was led, and the Lordship has admitted the extracurrial statement of Mr. Apollos, where a version of what happened was accepted by this court as a possible or probable version, in the sense as the evidence that led from the executorial statement by Mr. Pollis, that there was a discussion between himself and accused 3, that he had walked with Joshlin to Makalima's house. And that being so, then being accepted by this court, that is one of the grounds upon which he was then
Let's work with
convicted.
that. Let's work with that. He was in fact in loco parentis of the child on that day, Josh, but also broadly could be described as a parent to Josh.
Mr. Pollis.
Mr. Pollis.
Yes.
We're just dealing with
Yes.
Mr. Pollis.
Yes.
We have to look at his moral blameworthiness when we determine sentence. Now, yes, you've referred me to Ayuk. Ayuk's facts are very different.
Indeed, my lord.
Very different. Ayuk also, despite the fact that he played games during his trial, as Mr. Pollis did here, showed remorse. He had a total turnaround whilst he was in prison. And there were these psychologist reports and everything that was presented. And there was also a very different set of circumstances that led to the commission of the crime. He still got 10 years and there were many charges, so it mounted up. Then, on his version, because you say I was dealing with that, he knows that she's going to be sold. He positively participates in it. Then he hides the truth. If he had, for example, come and said, well, you know, I was under the influence of Miss Smith and I was using drugs on the day as he told the social worker, and yes, you know, I had no other choice or whatever excuse he wanted to come up with. He didn't use that opportunity.
Yeah.
He showed no remorse.
Yes, my lord. Yeah. I cannot argue against that, my lord.
Still doesn't show remorse.
Indeed, my lord, I can't argue against
And
that.
of course, I must be careful not to place too much emphasis on it, because accused persons or convicted persons might argue that I'm not going to say anything now because I want to take my chances in appeal, which is the good right of any individual to do. We heard this morning of the impact it has on society.
Yes, my lord. I was moved myself. It's in a very emotional setup. From my observation, I think Mr. Pollis was moved as well.
I'm not so sure of that. I was watching it. I was watching it.
Yeah.
I don't know whether you noticed that I did that.
Yes, I only saw.
I was observing the public gallery. And I was observing the 3 accused. I'll get to Mr. Van Rijn and he stares at me later.
Yeah. My observation was made when they came out now before we resumed now. That's, I couldn't see behind me, but I wonder if the presence of the 3 accused in the holding area maybe had an influence. It's my humble submission that I seem to have noticed something, but I'm just placing it there.
How do I measure any indication of potential remorse? Because remember, and there are a lot of authorities to it when it deals with remorse, of where it is focused. Is it self-centered? I know I'm facing a long sentence, I'm feeling sorry for myself, or is the remorse focused towards the victim? If it's an individual victim, in this case, it seems the whole community of victims.
Indeed, my lord.
Is there any indication of remorse being shown for the harm done? And in this case, the harm that's still continuing to be done. I referred in the judgment on the merits of the manner of reference to Joshlin, the kind. Heartless on the face of it. How do I deal with that?
My lord, all I can answer or submit in that respect is I would plead that one must bear in mind, as was also referred to in Mr. Peterson's report, in paragraph 10, where he says he had dropped out of school early, was never troublesome, had in fact engaged in a club rugby and conducted himself with social accepted norms. That was not what I wanted to refer to. There was a sentence here where Mr. Peterson referred to the area. And I think, yes, it's under paragraph 5, housing and environment. The second paragraph from the bottom on page 3 of my version.
We can go there.
In paragraph 5, there's a paragraph that starts that is a residential area where the offender resides with his family.
He comes from a good home.
Yeah.
And yes, he grew up in that area, and we find the same comment. It's the second paragraph under
Paragraph 5.
5.
Yes. Where it refers to suffers under this cause of social evils, which includes unplanned pregnancy, social ineptitudes. That I want to present as when, and I must be careful how I state this, my lord. Some people do not have the language eloquence and might sometimes refer to the kind, and some social groups might find it insensitive, whereas some individuals might refer to the kind not in a derogatory or unemotional way.
But in the context of when it was said and how it was said, would one not have expected a parent to use different terminology? It's objectifying Joshlin even at the time of the trial. And we're discussing this in the context of remorse.
I'm in agreement with your Lordship. I just would respectfully add that it must be borne in mind that the witness, when he was spoken to and questioned and cross-examined, that the stress levels were exceptionally high, which I'm not a psychologist, would suggest that it might be an explanation, and it cannot per se be, shouldn't per se be seen as derogatory or distantiating himself from any emotions towards the victim, Joshlin. As your Lordship has also become aware of, in the representation of this Exhibit SS probation report, there's now a difference between what Mr. Peterson says that Mr. Apollos told him and what Mr. Apollos said. And also when he mentioned that he had read this to Mr. Apollos yesterday morning, before he started, and Mr. Apollos didn't point out anything to him that he didn't agree with. My only submission in that regard would be that the stress levels are high, my Lord. I think it can be expected and assumed and accepted that the stress levels are high, and there's an idling mode, or not an idling mode, there's a high revving mode in the mind, and one maybe don't get the kind of detailed reaction as what would normally be obtained from somebody that was in a calm mode.
I find it strange, but also interesting. I've observed Mr. Apollos, and his demeanor in the court was different to Mr. Van Rijn and Mr. Smith. Always seemed to be nervous and very reserved, withdrawn sometimes in the courtroom. You will recall in the trial within a trial, on the day that Ms. Smith had to go for a medical procedure,
I was going to refer that to
his
that
demeanor was very different.
Yeah.
Very different.
Yeah.
On the stand.
Yeah. I recall
That was also the day when he conceded under oath the discussion that took place on the 18th. Now remember, I've heard the evidence of Mr. Peterson discussing all three. He now calls them offenders. And the influence maybe of Ms. Smith on him. So when he's in Malmesbury prison on the weekend, and he has this interview with Mr. Peterson. Because what is now suggested on behalf of your client and Mr. Van Rijn is Mr. Peterson sucked this out of his thumb. He made up a story. They're not coming to gainsay it. And then he tells Mr. Peterson things. Mr. Peterson comes here yesterday morning, and remember I asked for these signatures. I asked for those pages to be copied. He confirms. Then he gets in the witness ear in the courtroom, now all three are there, and then he flips. You want me to find that this is somebody that's remorseful? Or it was merely the revs that went up, or the heat that was more? It's a question that I have to consider.
I understand, my lord. I did not, on behalf of accused one, cross-examine Mr. Peterson. It was not my instructions to do that. I was...
But he now says Mr. Peterson has it wrong. He never said that to Mr. Peterson.
It was just the factual issues about the going to school by Joshlin. And then the difference is that Mr. Peterson said that Mr. Pollis told him that, and that's why he wrote it down there. Now, I just wanted to point that out, that I find it hard to believe. I cannot say that Mr. Peterson was lying.
But you see, if Mr. Pollis didn't say that to him, then he made it up.
My lord, I respectfully want to suggest another possibility, and that's a misunderstanding or miscommunication between the two of them. We know Mr. Peterson was under pressure. My submission is that Mr. Pollis has been all along, from Exhibit MM, saying, or his version was that Joshlin didn't go to school that day.
And he was flip-flopping on why she didn't go to school.
There was a few variants about why she didn't go to school, yes. If one look at different statements, a statement of Mr. Pollis, MM, the statement of Raquin, statement of accused 3. Yes, there were various
versions,
reasons.
Depending on the amount of reviews.
But as far as this report is concerned, the mere difference or the mere fact that I wanted to point out is that it can only be attributed to a misunderstanding or an error by Mr. Peterson, because I cannot see that Mr. Pollis, for any reason, would have spoken about Joshlin going to school or not going to school all day.
So let's get closer to... Tell me, where do I find the substantial and compelling circumstances?
My lord, that is where I was starting off when I mentioned the extracurrial statement. There is a version that the court accepted, and that is a role that Mr. Pollis played. As I've already mentioned, that he had a discussion with accused 3, that he walked with Joshlin to Makalima's house. That's the version.
And she was going to be sold.
And in terms of the discussion in terms of the discussion that took place, in terms of the extracurrial statement between himself and
remember, on his version, he fed her, and then he went to sell her. That's if I accept that version that we arguing on now.
Yeah.
Close your eyes and think about it. Where do I find, in his personal circumstances, the circumstances of the offence, on the evidence before this court, there's any mitigating circumstances? Forget about that. It's substantial and compelling.
If I may, my lord, I just want to go to the second version by the state. So this is the one version, the one going to Makalima. The other version is with Joshlin going to the polo. That's the other version. Now, there is also evidence then from Laurentia Lombard, and this court has accepted some of her evidence, but her evidence, I submit that in terms of her evidence, when she gave evidence about the discussions that she overheard, Mr. Pollis's attitude on 2 occasions, she gave evidence. Yeah.
Leave me out of this.
He distantiated himself from whatever was being discussed. Now, I submit that now we're sitting with 2 versions. He did something, and he indicated an attitude at a different time.
That's exactly why I raised the potential influence on him. But he didn't come and tell me that.
Indeed.
Even on sentence. Because when I listened to Ms. Lombard of that discussion on the Sunday, he immediately said, don't want to get involved in your nonsense.
Indeed, my lord.
Leave me out of it. But then he went along.
In the other version,
If for example, he had come and he said, remember, we're also dealing with the extracurricular statement. I was scared of Kelly. Or she had this type of influence on me. Or I didn't think straight because of the influence of the drugs. But now I'm clean. I regret what I did. It might have been a different story. Might have. I'm not saying it would have been. Saying might. But I've got nothing. All I have is, and we're just dealing with your client now, and let's accept his previous convictions is of no moment.
yes, indeed, no.
Let's accept he lived a stable life. He had opportunities. Some people use it, some people don't. Yes, he grew up in difficult circumstances. But there might be, and I know there are people in this courtroom that grew up in similar socioeconomic circumstances.
Yeah.
I was thinking this morning driving, because I had an invitation to speak at a function later in the year that came yesterday, and I was thinking of my primary school. Started in 1966 in Summerley. That school still has only 5 classrooms. And most of my classmates were people's children who worked on the farm.
Yes, my
And
lord.
very few finished school.
Yes, my lord, I'm very aware of
So, as I said, from what I heard here, it comes from a good home, a caring home. Yes, it took a wrong path.
yes, my lord.
Understand that. It can happen to anybody. But then, a la Mr. Peterson also, you then make choices. Turning to the 18th, he was averse to the idea, but then he made a choice of what happened on the 19th.
Yes, my lord.
I can just try and picture how callous that action of an adult is. Were you in a parental role? And his story, I gave her breakfast. I gave her the opportunity to bathe herself, wash her clothes. Then you look that child in the eye, and then you sell the child. How callous must a person be? Now, there may be reasons, but I don't have it.
Yes, my
It's, again, a choice he made.
Indeed, my lord, I'm in agreement with your lordship as far as that's concerned. I can't argue against that. What I would still, with the leave of the court, just take a little bit further is still section 14 of the Act, A. The aggravating factors. A is the significance of the role of the convicted person in the trafficking process. Now this is exactly what we are talking about, Mr. Pollard's role. Now, I'm in a difficult position to explain that certain aspects I cannot argue. I also act on instructions, my lord.
No, I understand that.
And that pertains to what your lordship has referred to on that Friday when the evidence was led and the Monday when the evidence was led. There was a difference. In that respect, I am not free to argue those effects on Mr. Apollos. But I do want to argue and persist with looking at his role. Yes, he made a mistake. He was spoken to. He did take a choice, made a choice. He was told to do this. That's the evidence. And he did it.
Keith, can I take you one step back?
Yes,
You referred me to Ayuk.
Yes.
And what's interestingly there, in dealing with the act itself, so the judge listed, say it wasn't this, it wasn't that, it wasn't this, it wasn't that. And it takes into account reports and so forth. But it's also tight, and it's mentioned in that judgment that you referred me to. That sentencing is the discretion of the trial court.
Yes, indeed.
Because you're still in the atmosphere of the trial. So you might have instructions or not have instructions to argue in a particular way, and the prosecutor will argue in a different way. But I can take into account my observations and my understanding of the case.
Yes, Mama, that was what was referred to in the Habib matter. Statements Habib specifically referred to Malchus, where it says that Malchus, it was said that sentencing is a lowly and onerous task. The imposition of sentence is the prerogative of the trial court. And I am at even with that. I understand that for a little bit that I've been involved, because the court has had and heard, seen appearances, attitudes, eyes, words, and that is exactly, yes, yeah. And that I'm at even with that. All I'm trying to do, my lord, is trying to, and I don't want to take too much time, but I also want to just go back to then Dr. Van der Wat's report. And I know it is his report, he's an expert in these matters, but the evidence was heard by this court, and this evidence will be considered by this court as to how it should be, how much weight it should be given. I don't have the specific reference, but in general, he spoke about this kidnapping is a pre-planned, organized act. I just want to submit something to the effect that kidnapping is a very organized business, heinous business.
He referred to it in the context of a premeditated act.
His words were, if I can just get to it where I made a note of it, he was referring to trafficking in general and then referred to this matter. His words were, paragraph 13, under the discussion on sentencing considerations, I think it is.
It's on page 18 of the report.
Yeah. What I wrote here, my lord, is the overwhelming majority of trafficking cases involve significant planning and deliberation on the part of the offenders. Now, I understand that this court has found that there was planning in this matter. in the selling of Joshlin. There was planning. There was a pre-consideration and dealings, must have been. Mr. Pollis was not part of the August 2023 evidence that was laid by Mr. Kutsia. Mr. Pollis wasn't part of that. I don't think he, at this stage, if I'm correct, at that stage he was not, I think, in accused 3's life yet.
Well, yeah, the way I understand the evidence is that Ms. Smith was unhappy with the setup that she found herself in. And that was her state of mind that she conveyed to Mr. Kutsia. And I can accept that that wasn't Mr. Pollis's view at the time. Because remember, she did not only say what was going to happen. She said, then she and Mr. Pollis can live in peace. They can have a better life. That was the evidence. Ms. Smith can shake her head as much as you want to now. I can see what she's doing. That was the evidence. So I can accept that. But that also fits in with the other possibilities that we spoke of earlier.
Yes, ma'am. Definitely.
Come and tell me that.
That is indeed
That's
so, my lord.
choice he made.
That is indeed so, my lord. So, to just round off the role that was played by Mr. Pollis, my submission is that it was a very limited role, and considering the position that he was in, how he reacted, and the decision that he made.
He executed the plan.
He did what he was told to do, my lord. He did what he was told to do.
If I would speculate, then I can take it into account and elevate that to a factor. That might be a possibility, and I'm saying it might be a possibility. But that's not how it will work. I have to deal with facts.
I just want to tie that up with that decision that was made, as your lordship had said, a decision he made. And as I submit, a messenger kind of transporter kind of role, that was in a state of being intoxicated with drugs. Whether that's going to affect his blameworthiness, I can't argue that, but I think in practical terms one must bear in mind at that stage he was not a right logical thinking, not in a right logical thinking mind. I think that can be sufficiently assumed and accepted.
Now let's accept that for a moment. Let's accept, because we know from Ms. Lombard's evidence, and that's common cause,
Yes.
that the three of them, and then Ms. Lombard as the fourth individual, were consuming copious amounts of methamphetamine and other stuff as well, over a prolonged period, but specifically that Sunday and the Monday. Let's accept that they were affected by these substances. Let's accept then that in that state of an altered mindset, the act is performed. Now dealing with the crime. But then, that evening still, Mr. Van Ryn and Mr. Pollers, they go and have their further drug binging. Let's accept that. So that's the Monday evening. Tuesday morning, reality strikes. What do? They actually frustrate the possibility of Joshlin being found. Now let's accept then that this altered state of mind, chemically induced, lessens the blameworthiness on the 19th. What does the actions post the 19th do? Doesn't it increase the moral blameworthiness? Or do you keep on that level of pain? And looking at it holistically then, does it not balance each other out? And then you look now, we're sitting, what's today? 28th of May, 2025, more than a year later. Still had the opportunity until now, this morning, to come and tell me this. Joshlin is still missing. And they're still throwing the lines on the wrong side of the boat. We've been discussing moral blameworthiness.
Yes, ma'am.
I'm now going to leave you alone so that you...
I cannot take that any further, my lord. One of my headings was drugs. We've dealt with that now. The drugs added a role to play. Whether that affects the blameworthiness, I can't argue that, my lord. There's one other, and I am mindful of the fact that in case law, and I think it is also mentioned in the Ayub matter by the Acting Justice Tibet, where she says there can be no prospects, or she finds it difficult to accept that there are prospects for rehabilitation if there is no remorse. I just want to, I'm mentioning that, my lord, because I want to argue that in the Ayub case in paragraph 48, page 12 of the copy that I have, Paragraph 48, my lord, if I may read it, it starts, it says, it was submitted on behalf of the accused that they could be rehabilitated even though they have not admitted to their crimes. And the next sentence is, this is difficult to understand as rehabilitation is not possible without a person accepting responsibility. I'm just mentioning that because it's my duty to place everything before the court. But I want to argue that, or submit that I respectfully disagree with that statement that it is that rehabilitation is not possible without a person accepting responsibility. My Lord, remorse, to become sorry for what you did. There is no definite time period where it sets in, I submit. Some people may never show remorse, and that might be a psychological thing. Other people take longer time.
I don't know whether, I don't know the context, because she's referring to a submission made
Yes.
by counsel.
Yes.
So I don't know what the context of the submission is, but as a matter of logic, it could also be on a timeline.
Yeah.
So at trial or at sentence, there can be a lack of remorse, but that remorse might kick in
Yes.
on day one of the sentence or 20 years down the line.
Indeed, my Lord.
And it might be focused at a particular point,
Yes,
in a different direction, and then you might have somebody rehabilitated.
Yes, my Lord.
Now, that's of course always possible to my mind, and that is why we have a system of parole. So
Yes.
when a person gets life imprisonment, the process is after serving a minimum of 25 years, the person will then go through the processes. And you see when we used to have the referrals back, remember with the old, the dangerous the criminals, those people come back to court. I've actually dealt with one or two where it's more than 20 years after the sentence, and then you see the reports on the individual and their conduct in prison. So that's possible, but how do you measure that at the stage of sentence? And I've indicated to you that the lack of remorse or remorse is not the primary factor here, because it needs to be balanced.
Yes.
You need to take it into account with everything. And I'm well aware that I shouldn't overemphasize it, because in a case like this, where the accused persons might believe that I still have a chance on appeal. I'm not going to say anything now.
Well, that'll be a gamble, my Lord, anyway.
So you shouldn't just say because of that. One need to balance these factors, all three or four of them, and any other factor that might be there.
Yes, my Lord. That's, we are all aware, I don't have it in front of me open now, that there might not be one specific factor that amounts to substantial compelling evidence, factor, but if there are a few aspects or factors joined together, one might get to a point where the court feels that there are some compelling and
but there are also authorities that indicate that in certain cases, in certain types of cases, and certain offences, that some of the factors to be taken into account will have less weight in this balancing exercise. And there's the old Afrikaans expression from a case that says dat gepaste omstandighede met die persoonlike omstandighede van die beskuldigde wyk voor die belange van die gemeenskap.
Yeah.
To translate that in appropriate circumstances.
Yes, my lord.
Personal circumstances, and I want to read in other factors should have less weight than the interests of society. And what is of Dr. van der Walt. Some of the opinions he expressed from the information that he has on the studies done and research done is the interest of society in these crimes, these types of crimes. And I'm in thinking about it, and I'm going to reflect a lot more in the next number of hours until tomorrow morning. In the case where a child is the victim, the primary victim, one has to go back to the values of us as a people. And that's protecting not only human dignity, but protecting the vulnerable in our society. And then we read that with section 28, so I'm looking at the preamble of the Constitution on page 28. And then we heed the warnings that our courts have expressed on how we should approach the matters where the interest of children in particular and vulnerable societies and members of that society in general comes into play. And it's not easy, and it won't be easy for me until tomorrow morning, because it's factors I need to take into account. And ultimately I have to remember and never forget that human beings are fallible, and I have 3 fallible human beings in front of me, and their lives are literally in my hands.
Indeed, my lord. Yeah. I mean, we're all very familiar with the gravity of the offence, the circumstances of the offender, and the public interest. Yeah, that's the balance that your lordship needs to find there. To just round off the aspect of rehabilitation, I'm just submitting to your lordship it's an aspect that should really be considered. And I want to stress and just again bring it under your lordship's, under the court's attention that in Mr. Peterson's report, Mr. Paulus is described as a quiet, reserved character. When one has, and I submit this with respect and humility, there are different, if one can do that, grades of criminals. You have your callous criminal, cold-hearted, in character, in mind, and in actions. Yes, the actions, what took place here, where Mr. Paulus is involved, yes, that is a heinous crime. It is very serious, involves a child. But I just want to submit that one must not, it needs to be borne in mind that considering from the Zin triad, his personal circumstances, that he is not this or a callous, cold-hearted.
What are the facts in Zin? in Zin?
Sorry,
What were the facts in Zin?
my lord, I can't remember that. I really cannot
You know
remember.
how old,
It's
what
very-
the age was of...
It's very old, my lord.
No, but do you know, no, it's an old case, but do you know what the age was of the accused?
I can't recall it, my lord. My memory is not that good anymore.
No, it's not a question of memory. It's a question of counsel referring me to cases and not knowing the facts.
I'm referring to your lordship to
I
a...
cautioned you about that.
Yeah, no, I'm referring to your lordship to a principle which is referred to as the triad of Zin. I'm not specifically referring your lordship to the Zin matter. I'm referring just to the principle of the triad of Zin.
And the same applies to Rabi. These are the two cases that illustrates either the triad and then coupled with the element of mercy. If mercy is an element. Because remember I referred to the three judgments. In both of those cases, the accused person was an elderly person. And the type of offenses were not what we're dealing with here. But over the years I've been constantly referred to Zin and Rabi. In fact, I argued them myself when I was an advocate.
Yeah. I'm just, for the sake of completeness, we all know, and I mean, I think it's right that there are the balancing, that there is this balancing act. And I can take the matter no further, my lord, as far as the possibility for any mitigating factors is concerned. I want to just address your lordship on one last aspect, and that is count 2 is kidnapping. I just have one. I know when it comes to sentencing, usually sentences run concurrently, unless it's specifically stated that doesn't run concurrently. But I think when there's a possibility of a life sentence and another sentence, it is bound to run concurrently.
If I impose life imprisonment on count 1, I need not say anything about the concurrency on
Yes.
count 2.
Yes.
Because by operation of the law,
Yes.
it will be served concurrently.
Indeed.
If I ever deviate and impose a lesser sentence on count 1, the parties need not address me on concurrency, because I'm of the view of the connectedness between the two, that the sentences should be served concurrently.
Yeah. Thank you. Thank you, my lord. I was going to refer to S versus Young, but I didn't. Yeah. It's not as your lordship says. Yeah. My lord,
It's because that's where the problem often lies, as a matter of interpretation, because it's a duplication of punishment, and then it gets elevated to a duplication of charges, and a big hullabaloo is made about that. But here, the kidnapping was an integral part of count 1.
with your lordship. Thank you, my lord.
It must run concurrently.
Yeah. My lord, then, unless your lordship is going to hear me on anything else, I'm not going to deal any further with the penalties, section 13, other than just, as I started off with saying, your lordship I can't find any case law on it. I cannot take it any further other than to submit that there might be some consideration to be given, as I've already read, paragraph 13, section 13 of the Act, where it says, including imprisonment for life. I would respectfully submit that maybe there is a difference in that it doesn't dictate that life should be given. It is an option. And then to just conclude, all of this to be viewed in that Mr. Pollis is effectively a first offender. His previous conviction was a petty theft thing, with I think it was 1,000 rand fine or something, but it was a petty theft.
No, I'm with you.
Yeah. So if there's nothing else, Lordship.
No, thank you.
Thank you.
Thank you, Mr. Kabay.
Must go in front. Thank you, my lord. It is correct that my client, Mr. Van Rijn, has been convicted of a very serious offense. It is further correct that he has maintained his innocence until this minute. I would like to argue my case from that angle. I have furnished the court with my authorities, but sadly, most of them, they refuse to download from my system.
No, I've opened many of them. And as we go along, I will open more. So don't be concerned about that. I'll give you the list in a moment. You've given me Zin, Rabi, Mutanti. Some of these references are references that I found the cases under a different reference. Banda, Mokoena, Smith, the Constitutional Court case in M. Mafu, Mlonyeni, Masota, and Tula. That was the 11 that you sent me.
There is a second list, my lord.
What second list that came?
I sent in the morning. It was 4:30, 4:15.
This was the list that was sent at
It was Marcus Machichi.
No. I also have open on my screen Malchas, Machichi, Habib, Ayuk, and others.
I forgot.
So if you sent everything that you sent, I've actually looked at. There were two sent this morning. But don't worry, if you want to refer to a case and I don't have it open, I can open it quickly.
Okay.
I've got access
Okay.
to everything here.
It is true that my client maintained his innocence from the start of the case up until this minute. I would submit before this honorable court that my client's silence or his denial of guilt may not be taken as an aggravating factor on the following grounds. My client didn't exhibit or is not exhibiting any chance or any opportunity of re-offending. My client is open to rehabilitation. Although he has maintained he's innocent, we respectfully submit that alone should not prevent this honorable court from giving due weight to his personal circumstances. They appear in the report that was filed by Mr. Peterson yesterday, but I wish to add the following. When the alleged offense was committed, my client was 27 years of age. My client today is 28 years of age. My client is a father to a 4-year-old daughter by the name of Hope.
Is she currently 4 years old? I saw it in the report.
Yes,
She's currently 4 years old.
yes. My further submission, my Lord, will be his stance on innocence must not at any manner diminish the fact that my client has suffered from the day he was arrested, including to date. I'm not going to go to the manner in which he suffered. The manner in which he suffered is before this honorable court. I'll go, my Lord, I'll refer to the case of State versus Banda. State versus Banda.
Banda.
This matter didn't download from my system, so I won't be having the facts of the matter.
So
but I'm having the principle.
Did you not read the case?
My Lord?
Did you not read the case?
No, I didn't. The whole case, my Lord.
So how do we know that it's relevant?
You will know that it is relevant from the principle, my Lord. State versus Banda, 1991, volume 2, SA.
Just one moment, I just want to find it.
Oh, sorry, my Lord.
Banda. No, 1991. So where did you find the case?
My lord?
So where did you find the case?
Yes, can I proceed, my lord?
Remember there were few cases of Banda around that time.
Let me leave it, my lord, if it's like that. I'll leave it.
No, if you want to refer me to the case, you've got to give me the facts. And I'll tell you why I'm asking you. Because there were a few Banda cases
That is the reason I'm saying I'm leaving it.
during
my lord.
that period. And do you know where it was decided?
Pope Tatswana,
Yeah.
my lord.
And what was it about?
I told the court, when I was reading the facts of the matter, my system couldn't download
But where
this
did you
matter.
get the facts?
My lord?
Where did you get the facts of that case?
When or where?
Where? Because you're telling me you read the facts. Where did you get it? That case has been referred to in a number of cases.
I got this from my old notes, my lord. My old references. In my old references, I didn't write the facts of the cases. It was only the principles. Now when I noticed that I don't have the facts in my old references, I tried to download these cases, but in vain.
What part of the case do you want to refer to? Where Friedman J made reference to the triad. In one of the Banda cases,
Yes.
in that 1991 2 case, it was presided over by Friedman J. As he then was. He was later on Friedman JP in the case.
Okay.
And it dealt with the potential overthrow of the government of Bophuthatswana at the time. And so far as it relates to sentence, he referred to the triad of circumstances. It was also quoted in the Constitutional Court in M versus Child Law. How does it help us? That's why I'm asking you, what is the principle you want to refer to? How does it help us here?
It will help us here, my Lord, in the principle of innocence, in the principle of the accused person remaining silent.
I'm listening.
In this matter, the court held that even if the accused maintains innocence, mitigating factors can and should be considered to avoid an unduly harsh sentence. I've mentioned above the mitigating factors.
I'm listening.
The mitigating factors in this matter pertaining my client's personal circumstances, my Lord.
Yeah.
It is my submission further that the denial of guilt does not preclude finding of rehabilitation potential, especially that my client previously was convicted and he has shown a sense or a measure of self-rehabilitating himself. It is my humble submission, therefore, that this court must not consider his silence as being lack of remorse. He is willing to reform, my Lord, even though he's still insisting on his innocence, but he's willing to reform. At his age, to reform won't be a challenge. That is something that he's looking up to reform and to rehabilitate. Further to these aspects of him insisting on his innocence, insisting on innocence, my Lord, is a right. And it cannot be referred to as someone who's showing a bad character before court. Is exercising his right and cannot on its own be inferred as a lack of remorse on his part. An accused person, my Lord, can still receive a lenient sentence, and his mitigating factors can still be considered even when he elects to maintain his innocence. Further, my Lord, it is true that my client has previous convictions. Now we need to look at the period when the first conviction was imposed upon the person of my client. It was the year 2014, and the last conviction, my Lord, was in the year 2020. I would submit, my Lord, that each and every case has to be individualized when the court want to determine a just and a proper sentence. Humble request this court not to look at the past of my client when determining a just and an appropriate sentence. My client was a youth at that time, and he was abusing substance. Humble request this court to take that into account when considering a proper and a just sentence. Humble request that the sentence process must still be fair and constitutional and not unduly punitive simply because the accused person has previous convictions or that he has maintained his innocence. That will help the court, that will help prevent the court from penalizing the accused solely for maintaining his innocence and for his previous convictions. My Lord,
I'm listening.
I will humble request refer this court to the matter of State versus Makiji.
Yeah.
I'm making reference to this matter regarding substantial and compelling circumstances. My learned colleague has listed this matter as the matter she will consider when arguing in sentence. I would like this court to go to the very first paragraph of this case. I will read it for the court, my Lord. In the case of State versus Machichi, 2011-1, SACR 40.
No, that's not the first paragraph of the case. A case will not start if it's Machichi to say in the case of Machichi. Which paragraph of Machichi do you want to refer to? We're looking at the SCA case.
Without making reference to the case, my lord, I know which part I want to refer to in this matter.
No, in Machichi, you took me to Machichi, so
Yes, it's still in Machichi,
so
my lord.
tell me about Machichi.
I'm still in Machichi, my lord.
Okay, what are the facts? What were the facts in Machichi?
The crimes took place in two separate incidents.
Yeah, but what were the crimes and how were they committed?
I'm
Because
going
remember,
there.
we're dealing with sentence here.
I'm going there, my lord.
Okay, so tell me the
Separate
facts.
incidents separated by 5 days. In the first incident, the respondent was one of the gang of 3 who attacked and robbed the complainant. In brackets, the complainant in this paragraph is Mr. AC. Mr. AC has been sitting in his car at the beach.
Well, his name actually appears in the judgment. You're reading from a summary.
Yes, my lord.
You're not reading from the case. Did you read the case itself? I cautioned counsel, and I'm repeating myself a number of times during the course of this case. If you want to quote a case to me, I want to know that it's relevant to the issue that we're arguing, and to know that we need to know what the ratio dicadendi is, and to determine that you need to know what the facts and the issues are. So I can tell you, the complainant in the first instance, right, his name was Anthony Cannon, and he was 45 years old. Because that's how the first paragraph of the judgment of the Supreme Court of Appeal starts. And then his car window got smashed in, and a wood was pulled over his head, and he was taken and he was tied to a tree, and his bank cards were taken, and they couldn't access these bank cards, and so on. And then his Honda Ballade was found. And then on another date, after the car was found, and he was then missing his JVC radio player that was taken from the car. That's when the persons with the initials KD and MF was abducted, and that's when the rapes and so forth took place.
Those are the same facts of the summary, my lord.
I don't want to talk about summaries. I want to talk about the case. But take me to the paragraph in the case that you say is relevant to our matter. Then we can go there. I've got it open in front of me. Which paragraph of Machichi do you want to refer to?
My lord, I want to refer to the facts of this case.
No, take me to the law point they want me to.
Thank you, my lord.
Machichi.
The law point I want to take this court to is,
Which,
in this matter,
which paragraph of Machichi? Which paragraph? The case is in the new style with paragraph numbers. So which paragraph number of Machichi
my lord,
do you want to refer me to?
when I was preparing my address in sentence, I used the summary. I didn't use the case. If the court wants me to refer it to the paragraph, I will humble request an adjournment. So
No,
that
you're not going to get it because you gave me that case on your on your list. Remember, you first sent me 2 cases. That was the 4 o'clock email this morning. And then there was another email that was sent at 6:34. Or it was forwarded to me at 6:34 by my registrar. By then I was already on my way here.
with due respect, my lord,
And I'm talking about the long list ending with the Constitutional Court case of Talu. So when I got here this morning, I started reading those cases. But Machichi is a well-known case. It's often referred to. Remember, it followed that whole long saga with Nkomo and that culminated in this judgment, and then there was also Chabalala and others dealing with the minimum sentences, if one can call it that, and then how to look at substantial and compelling circumstances having regard to the locus classicus of Mare J.A. in Malgas, because that was the first one in 2001. So, I've read the case and I'm going to have a look at it again tonight. So, carry on, skip the point.
my lord, the point I want to highlight in this case of Machichi is as follows. In the case of Machichi, there was a victim. A victim was called to court and the victim testified. In this matter that we're having before this court, we don't know the whereabouts of the victim. We don't know whether the victim has suffered any physical or psychological injuries. Yes, the community, through the voice of the social worker, has testified, but that is the community, is not the victim herself. Why I'm raising this point is because in the matter of Machichi, which my learned colleague has made reference to, in that matter, it is highlighted that when the judge is imposing a sentence, the victim-centered approach is very important. So this matter, my lord, I humbly submit that it is very irrelevant to the matter that is before court. The matter of Machichi, and on those 2 incidents, the complainants testified in court. They could testify to the injuries they have suffered. In this matter, there's no victim who could testify how she suffered, if indeed she suffered. That is the point I wanted to raise.
The state raised Machichi for a different reason. And with reference to Malgas as well. And the reason, and I'm reading in, is because what the Judge Akwo did in Machichi, he deviated from the prescribed minimum sentences. And this is not my view, I'm using the words of Marie J.A. in Malgas. Because he cautioned, the Supreme Court of Appeal cautioned in Malgas that these specified sentences should not be deviated from lightly or for flimsy reasons that you cannot defend. And I'm paraphrasing, I'm just using the flimsy and lightly from the words of Malgas. So you shouldn't look for reasons. And of course that goes back to Rabi with reference to foot in the Pandectus as to how judges should look at sentences. And that was the underlying common law approach which found its way into Zin. So in the judgment of Corbett in Rabi, he actually quotes the old Roman and Roman Dutch authorities from the Latin. And then also say you mustn't have anger, you mustn't be too harsh, but you mustn't have maudlin sympathy.
I agree with the court, my lord, but I'm still on my first point. First emphasis that was mentioned in this matter of Machichi. First emphasis that was made in...
Don't forget about the differences in the facts. Machichi is not a case to be used in mitigation. Machichi is a case that deals with aggravation, and so Machichi is not applicable to mitigation. But you don't have to refer me to Machichi. I've read Machichi. In fact, I have it open in front of me here. When I look to my right, I'm looking at the judgment. So carry on, skip Machichi.
Even if I still have some points in Machichi, my lord?
No, you don't have to refer me to Machichi further. The facts are very different, and the circumstances there were. These were armed robbers, kidnappers, because remember the person was taken to the wood and tied to the tree, and rapists. It's not applicable to your client.
Not applicable even in this case, my lord.
I'm sorry?
Not applicable even in this case of Joshlin, my lord.
It's not applicable to be applied for mitigation in respect of Mr. Van Ryn. And the principle is tried by now.
The other matter that my learned colleague made reference to is the case of Van Wenzel.
Which one?
Let me check the right. Where's this one? Just a minute, my lord. I've written it somewhere. Ivan Wenzel.
The case of? I've got Ayuk.
I want to check the full citation, my lord.
Just give me the name of the case, then I can find it.
Ivan Wenzel and the state.
Ivan? What? Yeah.
It's Wenzel, W-E-N-T-Z-E-L, and the state.
Okay. Just spell that name again.
W-E
W-U-E
N-T
N-T
Z-E-L.
Z-E-L.
Z-E-L. Yes.
Is it Wu Hensel or Wenzel?
In the cases that I sent to the registrar, I actually sent the judgment itself. It was an attached judgment. It's actually Ivan Wenzel. I-V-A-N-W-E-N-T-Z-E-L. It will not reflect as such on SAFLI because of the fact that the names are redacted. So on SAFLI it is reported as C and W.
C and W versus the state.
Versus the state, indeed, my lord. Case number A301, 2024, it's a reportable judgment.
I must have missed it on the emails that was, when was it sent?
Yesterday, my lord.
Was it attached? So was it sent to me yesterday? No, I got it. This judgment was given last week.
Indeed, my lord. That's why I'm saying it's a very recent judgment. It was delivered on the 13th of May, 2025.
Okay, I've got the judgment open. You can take me.
Thank you, my lord. Further to this case, my lord, it is my humble submission that this matter is irrelevant regarding the matter we're dealing with. In this matter, the complainant appeared in court, the complainant testified, and we could testify to her injuries. Charges were rape. In this matter, we don't have the victim. We don't know whether she received injuries. We don't know where she is as we speak. The matter that was quoted by my learned colleague, I humbly submit that this is irrelevant in this matter.
Yeah.
The other case she made reference to is State versus Ajuk.
Yes, I've got that one open as well.
Accused person in this matter faced 28 counts ranging from human trafficking, complainants in that matter testified in court. They could testify to their experiences. They could testify to their injuries. In our case, we don't have a complainant who came to testify. We don't know the injuries. We don't know whether she suffered injuries. We don't know the surrounding circumstances of her being trafficked or exploited. I humbly submit that even this case is irrelevant in this case.
Yeah.
Now, my lord, I want to argue the probation officer's report. At the court, I requested the probation officer to compile the report. It took only 3 weeks, or about 3 weeks, to be finalized. Mr. Peterson, who testified yesterday, didn't give consideration to the mitigating factors of my client. He was too focused with the aggravating factors in this matter. And his role is to prepare a report that is complete and balanced to assist the court to reach to a just and an appropriate sentence. He failed to do so. Mr. Peterson was very biased before this court. Other than giving recommendations, he gave orders. And as a result, I have to ask him whether he was a judge.
Because he showed the same biases as the judge.
I don't know about that. I'm speaking about Mr. Peterson, my lord.
No, I just wanted to know. Because that's what your client told you.
My lord?
Didn't you hear me?
No, I didn't.
I said I'd mention it to you because that's what your client told him.
My client...
So there's now a further person who must be blamed. He blamed everybody, including myself, for his dilemma. And now we must blame Mr. Peterson as well. But carry on.
I'm not blaming him, my lord. I'm arguing my case.
Yeah.
This is how I saw him.
Yeah. You're entitled to your view.
Further, my lord, he was very evasive. When I asked him, where did he get the information when he prepared his report? He was not clear whether he got some from the media. When I asked him, he said, no, not entirely, not complete. From there, he got summaries of the case. We were never asked to furnish the probation officers with our evidence. No heads of arguments for that matter.
Ms. Nkabai, I have to stop you. I was being patient by not interrupting you, but I'm not going to allow you to make submissions that is untrue. And I'll tell you why.
Yes, my lord.
You will recall at the appearance of the 9th of May, and it's on record, I indicated that I have prepared the drafts of the letters for the probation officers. And I invited everyone to give whatever information they wanted to be considered, including yourself. Now you say you were not invited to provide information. It was free to you. In fact, we held back on sending off the letters until you had an opportunity to add anything to be considered. And I'm aware that there were inputs made and names of people. That is why when I walked into court that morning, where you were present, as well as the other counsel for the state and the defense, after the parties had been in my chambers that morning, But I will only deal with what happened in open court. So, if you make a submission, make sure it's factually correct. Because the submission is made here, whilst the record of this case will reflect what happened on the 9th of May in Court 1 in Cape Town. Now we're back in Court 1. When we were at the 174 stage, I spoke about Court 1 where the state versus Beta was heard. Yes.
My Lord, this question was put to the witness yesterday.
I'm not challenging you on the question, I'm challenging you on the submission you made that were incorrect.
Mr. Peterson made it clear before this court that there are no mitigating factors as far as my client is concerned. Mr. Peterson showed a strange demeanor before this court when I was cross-examining him. When he was giving answers to my client, he continuously pointing at him when he was giving answers. He was also overly confident when he was giving his orders. I humbly view his report as not being biased. Coming to the report by Dr. van der Walt. Yes. Dr. van der Walt confirmed that he only received heads of arguments from the prosecution side. I will humbly submit that his report also is biased. I've mentioned that. My arguments were solely based on Makiki, and the court has told me not to make any reference to Makiki.
Yes.
Coming now to the punishment itself, my lord. When this honorable court is considering a sentence, we humbly submit that punishment should befit the criminal as well as the crime, be fair to the society, and be blended with a measure of mercy according to the circumstances. On the day in question, my client was solely selling his microwave. I would submit that he might have been at the wrong place at the wrong time. It is understandable, my Lord, and it is trite law that plainly any sentence imposed must have deterrent and retributive force. But of course, one must not sacrifice an accused person on the altar of deterrence. A sentence blended with a measure of mercy, we humbly submit that it won't sacrifice our client on the altar of deterrence. While deterrence and retribution are legitimate elements of punishment, they are not only ones, or for that matter, even the overriding ones. There are other factors this court must take into account. And this court must not penalize my client because of insisting on his innocence or because that he has a previous conviction. Each matter is decided on its own merits. It is true that it is in the interest of justice that crime should be punished. However, punishment that is excessive serves neither the interest of justice nor those of the society. If this court today can impose a severe sentence, I doubt the interest of justice will be served by that. I doubt the interest of the society will be served by that. There ought to be a balance. Balance takes into account that on the day in question, my client was only selling his microwave. There's a commentary I would like to refer this court to.
Yes.
It is by Foot, F-O-E-T. I would like to give this court the article.
Commentary.
V-O-E-T. On the Panditis, P-A-E.
I doubt that we'll find Foot
It's in,
on the internet. V-O-E-T. What
Yes,
is
my
the
lord.
reference?
Panditis, you open the brackets 5.
5.1.57.
That's
Close bracket. We won't find it on the internet. And I doubt that you've read it. I doubt that you've read it because you wouldn't have been able to find it here. There is a translated version, but it's written in Latin. And that one I referred you to is in the commentary at Pandecta. And you found it in a textbook, didn't you? Or somewhere?
Yes, my lord. It's just one sentence.
And you know where that person found it? That reference? Because very few of the sources exist. One of the places where the commentary actually can be found is in our library in Cape Town in the High Court. But nobody looks at it. You see, I told you, please don't refer me to a reference if you haven't read it. Because it's selectively quoted. But the easiest way to find it is to a case that you did refer me to. Remember I explained earlier that Corbett J.A. had gone back to the original common law sources when he discussed in Rabi how a court should approach a sentence from a sentencing perspective. Now, it's not because I'm clever. It's because I actually read Rabi this morning, early morning. I know you were awake because you sent emails that time of the morning. I read it this morning and it stuck in my head.
And this comment, my Lord, was made in the case of State versus Rabi.
It was made in Rabi. It was made in Rabi, and in Rabi itself. So Rabi goes back and refers to certain selections of the writings of Foot that was in Gaines, a translation, volume 2, page 72, where he refers to the writings of Cicero in the Roman Empire. And the comment is, this is now a quote from Gaines' translation of Foot. And it's quoted to read, "It is true, as Cicero says in his work on duties, book 1, chapter 25, that anger should be especially kept down in punishing, because he who comes to punishment in wrath will never hold the that middle course which lies between the too much and the too little. It is true also that it would be desirable that they who hold the office of judges should be like the laws, which approach punishment not in a spirit of anger, but in one of equity." This is Corbett J.A., later to become Corbett C.J., referring to Gaines' translation of Foot, where he previously referred to the section that I referred you earlier out of the commentary on the Pandecta. And he goes on and he deals with Van der Lingen and those ones that we learned about in Roman law, when Roman law was still a requirement for an LLB, many, many years ago.
Thank you, my Lord. In this matter of Rabi, Foot comments that there's a need for judges when imposing sentence.
Can I just
not to be.
Can I just mention to you, it's an important reminder to any person that has to impose sentence of trying to be fair, trying to be just, and not to let your emotions run away with you when you're dealing with the lives of people. It's an important reminder. Yes, there are old references, I've been referred to Rabbi so many times. I myself has referred to Rabbi in judgments. I've referred to Rabbi a lot of times standing where you are standing, because it's nice to refer to that element of mercy. But for those that haven't looked at this original case recently, it's a good reminder. When I read it this morning, it reminded me of my duty. So you're on the right path by taking me there.
Okay.
Yes, thank you. So, just in closing, so Corbett J.A. in that judgment, after dealing with all these old sources, and before he turns to discuss the 1969 case of Zinn, remember this judgment was in 1975, he said, and I quote, "Despite their antiquity, these wise remarks contain much that is relevant to contemporary circumstances." He also included a lot of other direct sayings from the old Latin. Those were still the judges that could read Latin.
In conclusion, my Lord, I will argue that there are substantial and compelling circumstances present in our case to warrant the court to depart from imposing a minimum sentence. I've mentioned them, my Lord. They are paying the probation officer's report. There's no need for me to mention them again. Without being disrespectful before this court, I would like the following also to be taken as a mitigating factor. The following to be taken as a mitigating factor when court is considering a just and fair trial. In criminal cases or in our criminal justice system, it is so important, it is vital in fact, for the complainants to participate or the victims to participate in crimes. Unfortunately so, in this matter, the victim could not participate. I will humbly request the court to consider that factor as a mitigating factor in this matter. I would like to refer this court to the matter of Marcus that is in front of the court. The judge in this matter was Corbett J.
Which one? To which case do you want to refer?
State versus Malchus.
Malchus was Marais, if I remember correctly.
Not Corbett.
Malchus
am having
was Marais. Yes, he was already a judge of appeal in 2001. It was Marais J.A. Remember, that was at the outset of the minimum sentences.
Can I give the court the full citation of this matter?
No, I have the case open here in front of me.
The Supreme Court of Appeals.
I'm not saying I know the case, but I've read it a couple of times, and I have it open in front of me. It's here. You don't have to give me the citation.
In this matter, the Supreme Court of Appeals held that ordinarily the prescribed sentence should be imposed and that the sentencing court should not deviate from the sentences for flimsy reasons. However, if the prescribed sentence would be unjust or disproportionate to the offense, then it must be departed. I've already placed before this honorable court the rare surrounding circumstances regarding the commission of the offense itself, or the rare circumstances regarding the disappearance of Joshlin and the fact that she couldn't testify. Having said the above, I humbly submit that the prescribed sentence in the circumstances of this case would be unjust or disproportionate. Someone will argue that the issue of the age, issue of my client abusing substance, issue of him being a father and a breadwinner cannot be regarded as mitigating factors. My submission on that will be as follows. It is also wrong to view circumstances as substantial and compelling only if they are exceptional, in the sense of being seldom encountered or rare. We're not looking for rare factors. We're not looking for seldom factors. We're looking for the personal circumstances of my client. And they are what they are. And they are to be regarded as mitigating factors.
Yes.
Humbly submit that may this honorable court, when determining a just sentence in this matter, must independently apply its mind to the question of whether the prescribed sentence is applicable or not. Taking all the evidence in total.
Yes. Anything else?
Yes, my Lord. I humbly submit that it will be a misdirection for a court to impose the prescribed sentence in the absence of evidence regarding the emotional impact of the complainant in this matter.
Yes.
We do not know the emotional or psychological status of the complainant. We don't even know whether she was abused or is being abused. We don't know her present well-being. To assume that she's likely abused will be a misdirection, which is highly speculative in the circumstances of this case. My Lord,
Yeah.
here we cannot describe the physical and the psychological harm suffered.
Can somebody maybe just help to adjust the microphone, because there are times when I can't hear you, Ms. Nkabai, because of the wind on the shutters. It makes a noise, and I want to hear you. Thank you. Thank you.
Thank you, my Lord.
You covered most of the issues that one could cover, but if you have further submissions, let's get to it.
If the court can be patient with me, my Lord.
I have been very patient, Ms. Nkabai.
I have made a reference to the principle in the matter of state versus Zen.
State versus?
State versus Zen.
Zen.
I've mentioned the issue of
Yeah, no.
punishment being blended with mercy. Those are my submissions, my Lord.
Thank you. Mr. Signarayan. Mr. Harms is looking at me as if he wants an adjournment. If I take an adjournment, I'm going to take it for 5 minutes or so, or 10 minutes. I'll tell you why. You would have realized that I have a major task ahead of me till tomorrow morning. So I want to get out of here as soon as possible. I want to conclude the arguments so that I can go and work in order for me to deliver the sentence in the morning. So, are you ready to proceed? You want to take a break? Don't look at him.
My Lord, I do not intend being very long, but I would appreciate that as well.
Let's take until 1 o'clock. It's 13 minutes. Then we're going to come back. And then we can hear you in the state, and then finito.
Thank you, my Lord.
In the meantime, we must get stuff ready to pack, Jerry. All of this going home with me. But when we're done, we need to move. And the one with, I think, section 277 roundabout there. Court adjourned.
but
Hand it up, it's fine. You're not going to object, Ms. Honorable. This is like, I'm just going to see, we're going to, it's testimonials from the family, as we would normally have from the bar at sentence. I'm going to accept it. And
My Lord, if I just may, this was jumped on me now as a surprise. They were referred to, what my learned colleague was referred to now, she actually said testimonies. In other words, affidavits, not testimonials.
these are affidavits. That's fine. I'm going to take it. We'll make copies for all of you. And if you have any response to it, I doubt that you will have to give me responses. The parties can make short submissions on the written form by midnight tonight, if you want to, right? But I will accept it in evidence. I'm going to mark it one bundle, and it will be double W, right? And my registrar will make copies for everyone, and then we'll deal with it that way. As I've indicated earlier to Mr. Harmse when he started, I'm not going to exclude any issue, so I will have regard to it. I can see from the addresses on it, it's mostly people that's not living in Saldanha. You can see the last one is somebody that lives in Calvinia, and looking at the name, I haven't looked at the details. I can see that name appears in the social workers report. Roche Strauss, the person living in Calvinia, who is the mother of the 4-year-old. So, Ms. Naidu Chetty, if you can just later on just make copies for the defense and for the state. I'll take the originals with me in the file that I'm going to take with me tonight, and I will deal with it. Thank you.
Thank you, my Lord. My Lord, the room to examine this is the sentence and factors into consideration. The personal circumstances of the accused. She is at present 35 years of age. She is unmarried, however, she is in a relationship with accused number 1. She has 3 children. A boy by the name of Requin, and 2 girls, Joshlin and Rochelle, and they are 12, 8, and 5 years old respectively. Prior to her arrest, accused number 3 resided in her own home in the Middle Post area. That home, which has recently, well, on the 2nd of May, been burnt down. She completed grade 12 at Diazville High School in the year 2008. She was employed as a domestic worker in the area of Middle Post and generated an income of approximately 2,000 Rand per month. She has no previous convictions or pending cases against her. She is a first offender. It is her first encounter with the law. She, at 35 years old, she is fairly young. Even though she was a drug user, she still found employment and supported herself as well as her family. Prior to her arrest, she was the primary caregiver. She took care of accused number one as well as the children of the 204 witness in this matter.
In fact, the evidence suggests that in this friendship group and in the household, she was the sole provider.
That is correct.
And Ms. Lombard's evidence is that she was generous and always assisted or sharing with the neighbors and so forth.
On that point, my lord, I wish to add that she was a contributing member to society in that sense. She was employed and she assisted those who she could in the society or in the community. My lord, looking at her personal circumstances, it's clear that accused number 3 had a difficult life. She unfortunately succumbed to the use of drugs, which made her situation even worse. Her use of drugs began approximately 20 years ago, my lord, and that, I submit, would have had a significant effect on her. And in that regard, I submit it should be viewed as a mitigating factor. My lord, with regard to substantial and compelling circumstances, I submit that looking at the personal circumstances of the accused cumulatively, they amount to substantial and compelling circumstances, especially with regard to her age and that she is a first offender. She has the ability to be rehabilitated and to be placed back into society and to become yet again a positive contributing member to society. And for those reasons, my lord, I submit that cumulatively those amount to substantial and compelling circumstances. My lord, I have no further address. There was no address with regard to section 103. I don't know if the court requires an address in that regard. Those are my submissions, my lord, unless there's any issue the court wishes me to deal with.
The same principles as was set out by your colleagues applies to her as well.
That is correct, my lord. I agree with the fact that the court cannot deviate from the prescribed minimum sentence for flimsy reasons.
But?
Yes,
is there a but?
But every circumstance of the accused has to be taken into consideration. Although there is a prescribed sentence set out by the legislature, the court still has a discretion and is not bound by that minimum sentence. If the court finds that based on the circumstances of the accused, it justifies a deviation from the minimum sentence, or that the sentence that should be imposed warrants a deviation, the court has the discretion to impose such sentence, my lord. Those are my submissions, my lord.
Thank you.
Thank you, my lord.
Ms. Swanepoel. Now, you don't have to address me on the principles, etc. We've gone through that. You've heard me comment. I want to hear you on two things only. One is, as to count 2, is there a prescribed sentence in that regard? No. And I've indicated to the defense that depending on what type of sentence I impose on count 1, I will indicate that the sentence on count 2 must be served concurrently. The state has no issues with that. I take it because you referred me to the cases that you referred me to, that you're going to ask for life imprisonment on count 1. Briefly, don't have to go into all the detail, I've got the facts. You may highlight those facts that you believe are aggravating to the extent that whatever is put up on the other side of the scale does not tilt it in that way. I don't want to steal your thunder, but we don't have to be long on it. The principles are right.
No, of course, my lord. And I understand that. And yes, I am prepared, and I have submitted the cases that I think are applicable in this instance. But if you will allow me, as far as the kidnapping count is concerned, no, there is no minimum prescribed sentence applicable there. It is in the discretion of this honourable court. But
the normal factors will apply, and here we have a position of trust. Over and above your normal kidnapping, this is effectively parents being involved in depriving a child of her liberty. And yes, it's what I make of it. There's no indication of physical harm. Defense argues there's no emotional harm, but isn't that a question of inferential reasoning by having to accept? I've tried to illustrate to Mr. Harmse from Mr. Apollos' perspective of how he viewed Joshlin on the day. But should we not think in what if it was not immediate, supposing she was still playing around, but am I not going home? Should one not infer that a child or any person going through that will be under severe emotional stress?
absolutely, my lord. My lord, and now I'm jumping my own arguments ahead, but after listening to the arguments today, I am stunned to think that it can be argued that because the victim in this case has not been found, because we do not have her version, because she wasn't here to physically testify about what happened to her, that is a mitigating factor. I wish to argue completely to the contrary. That's an aggravating factor par excellence. We don't have her. We don't know where she is. We don't know whether she's alive or not. We want to hope that she is still alive. But is she being exploited? We don't know. Those are all those questions in the air. And all of that is aggravating. My lord, and it's because of that we adduced the evidence today to give a voice to Joshlin, who is not here. And it was specifically planned in that way, starting with the community from afar, and then coming closer to the school, and coming closer to the family, coming closer to the grootmagma at the end. First the sister, then the grootmagma. And I'm referring to sister being Natasha Andrews.
So, in determining the question of emphasis is placed on that Joshlin was the victim, how far does the victimhood go in a case like this?
My Lord,
Who are the victims?
yes, my Lord, that is exactly why I referred to the cases that I referred to. And specifically in the matter of, I think it's in the Ayuk matter. Yes.
I'm not going to open it up again.
Okay, but my Lord,
because I've read it.
It actually says that the victim is not only the victim, it's also the people surrounding the victim and going as far as the community. In this instance, I want to say that yes, I agree. It's the whole community. It's not even just Saldanha, Langebaan, South Africa. It's internationally. My Lord, everybody is looking at this case and wondering and asking, where is she? Why are they not coming? Why are they not saying? Why are they not taking the court?
I'm listening to the, and I was reading first, and then I was listening, reading at the same time. So as
Dr. van der Walt,
the witness testified this morning, she was saying it in Afrikaans. And I was following the statements in Afrikaans, and then it was interpreted into English. And then you hear the words again. But I want to refer to Mrs. Daniels with respect. And it can't be easy for her to be here. But the victimhood of the family, Kelly's family, the trauma, the children, and a mother, when she says, if Rico is a few minutes late from school or from his rugby practice, I actually, and she used an Afrikaans expression of going up the road to go and search. Forget about the other expressions of emotions. What do I make of that?
for sure.
And then you have, as you say, now we're counting all those phases, the classmates, the teacher, the trauma that the school children and the whole school go through. Mrs. Mart says that, you know, now there's an increase of parents fetching their children from the school. Will Saldanha ever be the same
For sure not.
after this case?
For sure not. And immediately I think of Mr. Kutsia's testimony of what he was told. Jy sal hierdie plek nie ken nie. Isn't it so that this incident has changed the whole community, has changed our way of looking at things? And unfortunately, I'm now, it's going to seem as if I'm jumping around, but I want to support the suggestion that actually, in fact, it is time. It has become time that we should move away from the triad when we consider sentence and add that fourth one. Add that fourth element being the consequences, the fourth C, the consequences for the victim impact statement, the impact that it had on the victim and the people around the victim, the circumstances thereof. That is the reason why we tried to give a voice to our victim. And in this instance, my Lord, I submit with respect that the court in its reasoning, and I'm referring to the last two cases that I referred to, the Western Cape High Court cases, suggested that perhaps it's time. It's time that we actually include that fourth factor. And in this instance, even more so. Even more because we don't know where little Joshlin is.
Remember, it was that whole debate of whether it's an additional factor or not was raised in Rabi.
Yes.
That was the debate had between the three judges. One says, no, it must be an element. The other says, no. You know, we conservative as lawyers. We don't want to change things that work. So we rather read in. Now my thinking is, do you create new law by putting it on its own, or can it be read in the interest of the community? Or do you go to the value of creating a balanced society and say that must come to the fore more, and therefore it's elevated to more than an influencing factor, but rather an element?
Yes.
It's something that I've got to think about.
Yes.
In fact, I have been thinking about it. I haven't found an answer in my head.
My Lord, that's exactly why I'm referring to it. This is a case for new things. Many new things happen in this matter. And I want to urge the court to consider actually elevating that to the level of being an element to consider. There's enough case law that says we need to consider the interests of the victim and the impact of the offence on the victim. There's enough case law that says victim impact statements is something that you cannot go without. It's necessary. That picture of the tree with the leaves being the thumbprints and that one little branch that has nothing, it's being kept open for little Joshlin. My Lord, I want to actually just take 2 steps back. Mr. Harmse, in his address, referred to Section 13 in the Pakotip Act. I want to say, in this instance, the case law abounds. We're not starting from a clean slate. We're starting from the point of the minimum sentence. A minimum discretionary sentence is applicable. It's life imprisonment. It's only, and I'm not saying that the court doesn't have a discretion. The court does have a discretion. But it can only be exercised once it has been proven that there are substantial and compelling circumstances to deviate from that sentence. Mr. Harmse refers to Section 13 in the Pakotip Act. That is the one section in that piece of legislation that we are still being criticized for, South Africa. In the US Tiptier report that we read every year, that comes out every year, we are criticized specifically for that section because there's still the possibility of a fine. Why is it not only imprisonment as a sentence option? Dr. van der Walt in his testimony also referred to that and referred to the fact that we are being criticized. There's a logical explanation. The logical explanation comes in when you convict a person of contravention of Section 9, liability of a carrier, and it's a carrier, it's a company that's convicted. Company cannot be sent to prison. So what is the alternative to it? There must be a fine. So there's a logical reasoning, but that is not always seen when being criticized. And especially when it's other jurisdictions and other countries that's doing the criticism. So, be that as it may.
We're not criticizing them for imposing Methuselah sentences.
Indeed, my Lord. What I'm saying is, that cannot be seen to be a reason to now deviate and see it as mitigating. The minimum sentence
Is it
applicable.
is it not a question of interpreting the act and for the jurisprudence to be developed so that there's no doubt where the emphasis lies? So I made the comment to Mr. Harmse this morning by taking the vulnerability, and that's general, the vulnerability of persons that are being trafficked. And then you add on to that, and I don't want to call it a double vulnerability, when you deal with a child. And then you look at what is the purpose of the law and what is our duty as the courts. Duty of the courts is to protect those values in the Constitution, and both the human dignity and the protection of the vulnerable, and building a harmonious society of values that you need to uphold, underpinned also when it's a child by Section 28.
Absolutely. Paramount importance. Definitely. I agree. Completely. My Lord, I just wanted to say, and just to refer, just for my sake of my argument, please, with regards to Section 13, when one looks at Section 51 in the Minimum Sentences Act, it actually reads, notwithstanding any other law. This must be the sentence. So I think I've made my point. The Minimum Sentences Act is applicable and life imprisonment is a prescribed sentence. The question is simple. Are there any substantial and compelling circumstances raised today or by any of the evidence, singularly or cumulatively viewed, that can be seen to be substantial and compelling circumstances? My submission is no, there's nothing. Not even if one wants to feel sympathy for any of the accused, especially accused number 3, being a woman, being the mother. My Lord, my submission is completely to the contrary.
But then you go back to Rabi.
Yes, yes. And each sentence must be tempered with some mercy. But that's why I'm saying we should start at the minimum sentence. That's what's the applicable, appropriate sentence.
Is it the sentence that's been tempered with mercy? And it might be a question of semantics. But is it the sentence that's tempered by applying mercy? Because that would suggest that you determine a sentence and then you say, I deduct a 10%. Or is the correct approach that each factor and circumstance and fact that you take into account, that's tempered with a measure of mercy. So mercy follows right through from beginning to end. Isn't that what was meant by the Corbett JA judgment in Rabi?
That is possible, my Lord.
Because otherwise, also, a la the Supreme Court of Appeal, that's when you make the mistake of just getting soft.
Yes, yes, definitely.
Still following the foot, not being too harsh and angry.
No, for sure, my Lord. And courts deal with these in innovative ways. In one of the cases that I referred, my Lordship, to, the court actually imposed life imprisonment, but said that it would be as if it had been imposed earlier. So in other words, to make up for the time that the accused had been in custody for such a long time, the sentence was then dated to the time that it should have been imposed. My Lord, if I may, in this instance, we have seen probation officers' reports, and for the first time in my career, I see a social worker, probation officer, who actually digs in his heels and sticks to it.
How long have you been around?
Unfortunately, more than 30 years, my Lord.
I've been around much longer.
I agree, but unfortunately I'm giving my age away. But
It's the first time that I've seen a probation officer dig in his heels like Mr. Peterson.
yes, indeed.
You mostly find that they're too scared to stick their neck out and then come with all sorts of alternatives in the reports. You know, that's just the nature of the reports.
Absolutely. But in this instance, he comes and he says, even at this late stage, even at the stage when I interview these people, they're still telling me lies. And when I confront them with it, accused number one, about the not going to school or going to school, he was filled with stupefied silence. He just sat there and couldn't give any explanation. There's no room for misunderstanding.
I was the hardest argues because the rates got higher.
Yes. My Lord, I will leave that as it is. My submission is, Mr. Peterson was clear in his evaluation, and he has given well-founded reasons for his recommendation. His recommendation is this court should impose imprisonment and imprisonment for a long time. That fits in with the prescribed minimum sentence of life imprisonment. Then I go to Dr. van der Walt. Dr. van der Walt is the expert. I don't think anybody can doubt that for a second. He deals with the factors as listed in Section 14 in the Public Act. And he deals with those that are applicable in this instance. I submit with respect that his evaluation there is correct, and I agree therewith that those are the factors that are indeed the aggravating factors that the court must consider, because that's what the legislation says. It's a peremptory section that deals with that. If we look at the position of accused number one, he was in actually position of a parent on the day that Joshlin went missing. It was on his watch that she went missing. And I'm not going to go into too much detail, but I do submit with respect that as far as he is concerned, there is no substantial or compelling circumstances whatsoever. Accused number two is regarded and was aired.
You're going to use those words.
Yes, my Lord, because it was not my witness, it was the court's witness. And the witness repeated them a number of times that he's a menace to society. And if one looks at his previous convictions and the time frames, then he has had the possibility of a number and the opportunity to have a number of different sentence options. None of them has rehabilitated him until now.
But was he not just a joiner?
My Lord, a joiner?
Yes, he's an accomplice.
Yes.
He's a co-perpetrator. But was he not a joiner, a late joiner to this event?
My Lord.
That I should take into account for sentence purposes?
My Lord, with respect, The evidence that this court has accepted is that there was an agreement before the transaction of which he was part. On his own version, he's the one who, on his version, Joshlin is delivered, he's the one who goes back the next day. Why? Because he wants to go and ask his cut on the deal, which is 5,000 rand, according to him. So, my lord, this is not the actions of a late joiner who's just at the wrong place at the wrong time, as has been argued today. I submit with respect not. It's also the same person who was laughing throughout most of the proceedings in this court. Also yesterday, all three the accused were still laughing in court, whilst we are dealing with the sentencing, and this honourable court has to decide which sentence to impose. It's not a laughing matter. My lord, I submit with respect that, as Mr. Peterson says, there's no mitigation as far as accused number 2 is concerned. And I submit that life imprisonment is the appropriate sentence. As far as accused number 3 is concerned, she is the mother. Yes, she's a first offender. That in itself, case law makes it clear, that in itself is not a substantial and compelling circumstance. It's argued that her age, I don't know how the age really has any bearing on it. She's the eldest of the 3 accused. According to the evidence, she's the one with the strong personality, with the will and the willpower. Evidence suggests that she was the mastermind. She's the one who came up with this idea the previous year already. None of them came and said, as the court correctly this morning also referred to, none of them came and said, I was manipulated or intimidated or anything like that, influenced to take part. They didn't do that. But she herself is the leading personality. Yes, she's the one who was gainfully employed, although not permanently, but she tried. She assisted. Was she and is she a primary caregiver of the children? Should that be considered? If we look at the case of State versus M, it's something that the court must consider.
Well, you know, of course, that M, there were also a number of amici that were part of that case. So, the principle is said that one must just be careful. But Mr. Peterson, by implication, covered that.
Yes, indeed.
In his report.
Yes.
Because he addressed that issue.
Yes. And I suppose
insofar as it relates to the minor children, and we also we're aware of the current circumstances.
Yes, of the children.
Of the children. The 2 that we know the whereabouts of.
Yes.
But he makes the point on page 7 of 8 under the heading 14. He deals with that.
Yes, he does. He does.
So that might cover the concern that the courts must have when incarcerating a primary caregiver.
Yes. Indeed.
But does the nature of this offence not also change the landscape?
for sure, without a doubt, especially because of the facts of this case. It is her own child. And that in itself should say enough. My Lord, but I want to, with respect, just take it one step further.
I'm with you.
This is Miss Smith, who decides months prior to the actual transaction to sell her own child. So one could ask, is this an act of desperation? Is it because there's no way out? Did she not have any other possibility but to succumb to this? My Lord, I want to argue that no, that is not the case. She did have support in the persons of Kelly Zegers, Colin Zegers. It was the testimony of Kelly Zegers that on the Sunday prior to this Monday of this event, she still bought her 500 rands of groceries, delivered it to the house. Kelly Zegers says, Miss Smith comes to our house every day. She feeds them, feeds the children. She feels sorry for them. She assists them. Kelly says the same thing, Kelly Zegers. So we have the Zegers family that cares for them, that assists them, sometimes by money, sometimes by food, between the two of them. Added to that, we've got Natasha Andrews and her family, who care for Joshlin, who has accepted Joshlin as part of their family. This court viewed the video today with all of the photographs of Joshlin being part of that family, playing with her sister, learning to count to the end of that video, and laughing. That laughter that was also described in the victim impact statement. My Lord, Miss Smith had an option. She could have just agreed to the adoption, and she wouldn't have had the responsibility of looking after Joshlin anymore. But she decided not to. Now, what other inference can be drawn than to find that this offense was fueled by greed?
So let's
by
take,
money.
let's take the question of the payment is one issue. But we have the words uttered towards Mr. Kutsia in August, which suggest a motivation.
Yes.
And that's not fueled by money,
No.
but rather something else. Then you have the agreement and the underlying reason for the agreement that Mr. Apollos himself had indicated in his extracurricular statement. And it so happens that those were not facts that would have been known to the police or anybody else. And that's the insistence of Miss Andrews and her family, Mr. Emke and his attitude towards it, and therefore this is going to happen. Now I'm raising these facts also in relation to M, because the primary ratio in M relates to the fact that when courts impose incarceration, Section 28 rights remain paramount.
Absolutely. Absolutely. Absolutely, my lord. I agree. And under these circumstances, yes.
So can it be in the best interest of a minor child, of a mother that acts like that, to keep the mother around?
Never.
That's just the question. It's not to find me.
No, of course not, my lord. But that is my argument. This is the problem, and I'm saying this with respect. This problem is causing interference from other people in my family life. We would rather live in peace, just the two of us, not have this problem anymore. So let's get rid of the problem. And isn't that what we have here? We commodify a person, a little Joshlin. And under the circumstances, if one, because today in court we hear and we see Miss Smith being very emotional and crying after having seen and heard all of these things. But I want to, with respect, my lord, say that is a little too late to cry now. My lord.
Can you maybe I want to go to an exhibit. Where is just want to find out where it is. Geraldine, Miss Naidu Chetty, where are you? Where's the exhibit that's in the envelope? Exhibit Z in the main file. You've made a submission in which leverage file? I just want to find the exhibit. I'm not going to read everything out. Okay. It's exhibit Z. It's we kept it in an envelope because it's a statement of a minor child.
Yes, who did not testify, my lord.
Z.
It's Z1 and Z2.
Yeah. It's not in there.
Z1 and Z2.
Do you maybe have a copy at hand there for me?
I do.
Can you just pass it to me, please? It's somewhere, we kept it, it's somewhere in that pile, but we had it in a file. So in paragraph 9 of Z1, he makes a statement. Now remember, this was handed in. Okay, give this back to them. Thank you. In paragraph 9 of Z1, he makes a statement and says certain things.
Yes.
About the conditions prevailing at the house. Now, yes, he didn't testify in the main trial. The statement was handed up.
Yes.
We now at sentence. What do I make of that?
Oh, my lord. without sounding harsh, that maybe he and his sister are better off where they are now.
I raise it also a la M.
Yes, of course. My Lord, because this is not the only indication. We must also remember the evidence of Paulina,
Yeah.
Joshlin, which also goes to that way. We must also remember the evidence of Laurentia Lombard, who clearly indicated that that was a very volatile.
And then we have Mr. Peterson's evidence from what he was told, how the children were physically treated.
Indeed.
I don't want to call it abuse, I don't want to call it assault, rather say how they were physically treated.
And the complaints that were known to the DSD, confirmed by Ms. Mbomba, who also testified about it. So I think the indications, my Lord, to answer my Lord's question is, my submission is a little too late. When we say, I am famous, and that's the most important thing, because of my child, that is not what we would want, and a place where we would want young children to be. Under the circumstances, my Lord, I submit that there are no substantial and compelling circumstances, and that indeed life imprisonment is the appropriate sentence for all three the accused, and that there shouldn't be any differentiation between them, despite the fact that accused number 2 has so much more previous convictions. I think life imprisonment is the appropriate sentence. And may I at this stage also, my Lord, just add in a request from the state side in terms of section 120 of the Children's Act. It was referred to in the indictment. Given the finding that this court has made and the fact that we are dealing with a child victim, the state requests that the court also makes, and it's a discretionary thing, the state requests that the court makes a finding that all three the accused's names should be entered in the Child Protection Register as people not fit.
Does it exist?
My Lord, on paper, I want to be optimistic, and I'm not going to fall into those arguments.
Well,
but I do.
In the event that I impose life imprisonment, is it still relevant, or do you want to look forward to one day?
Yes, my Lord. Unfortunately or fortunately, the accused are still in their 30s, 20s, 30s. They're still relatively young. Court referred to minimum parole time, 25 years. So there is still scope that they might want to one day work with children. I submit that they are not supposed to be allowed to work with children. And that's the request from the state side.
Of course, they might even be allowed. So I'm just thinking aloud within the correctional setting. Remember, you have like mother and baby units where offenders are assisting. You might have at a facility where they come into contact with children. So you want to make, make that an order.
Indeed, my Lord, that's the reason.
How do I ensure that the order I make in that regard, because irrespective of the sentence, the order must follow, that it's complied with? Remember, I posed the question whether it exists. But is this not an opportunity in the event that they make the order, to ensure that there's a report back to me that it was in fact done.
That is an excellent suggestion, my Lord, and I request this Honourable Court to do that.
So who's the responsible agency that must make that? Because I need to put it in the order that I want X, Y, Z to file a report with the registrar by date X
As I understand this, my Lord, and
with proof of compliance of this order.
as I understand it, my Lord, the obligation lies on, once the order is made, the registrar to send it through to National DSD office. If it goes through provincial first and then to National DSD, but that's the route that it should go, and to Department of Justice.
So it will be the Director General
Yes,
of the Department of Social Development
indeed.
to report
Department
to
of-
the Chief Registrar of the High Court
As
before or on a certain date that there has been full compliance with the order.
As I have it, it's the responsibility of the Department of Social Development coupled with the Department of Justice.
Now that raises another question of reporting of these type of offences. Remember, the Act envisage and places an obligation of certain things to happen. And I've made a comment in passing in the judgment. Do I say anything about that? That's over and above the sentence I imposed.
No. Indeed, my Lord. My Lord, I can keep you busy for a very long time to try to explain the lengths at which we have already gone to try to get that data in place. It's a multi-sectoral, multidisciplinary approach. I'm part of NICTIP, the National Intersectoral Committee on Trafficking in Persons. I sit on that body. This has come for years, as long as trafficking in persons has been, and I've started in 2007 with it already.
But the
So
Act says there must be a register and this is how it must be done.
It is, my Lord, but now you have different departments and all of them have their own specific responsibility in terms of Section 44, that they should keep certain statistics.
So who's
every department
the
keeps-
who's the lead department?
It would be the chairperson of the National Intersectoral Committee on Trafficking in Persons. I can provide the court with the particulars of that person. He's the deputy DG of.
No, I don't want the name. I want the designation.
Yes.
And isn't the DG the accounting officer of every department?
Yes, of the different departments. That is so. My Lord, can I just explain? So there has been this tool created, electronic tool created. First from SADC, from everywhere.
I don't care about the logistics. The Act prescribes
I know.
what must be done.
I know.
I have now convicted individuals under that Act.
Indeed.
I'm considering it still, of making an order that there is full compliance with the law insofar as it relates to this matter.
My Lord,
How it's done, none of my business.
My Lord, that is why when Advocate Dr. van der Walt testified, he referred to the table, and the table is attached. Dr. Beatrice Creer is the one currently in South Africa keeping record of all of the trafficking in persons convictions. Furthermore, in the NPA, we have a database of all the cases. In the province, it's me. It's my responsibility. So the data is kept. From the police's side, the DPCI tip nodal point keeps.
Can
in
you
every province to the-
Can you provide my registrar with the the lead department that's responsible for compliance with that section,
It's Department of Justice.
so that I can consider it. Right. Anything else?
Thank you, my lord. I rest.
And of course, the normal declaration in terms of the Firearms Act,
Although
and that
excuse me.
follows, but I don't think it's necessary, yeah.
I think accused number 2 has already been declared.
No, accused number 2 has already been declared. Because he was convicted of violence.
Yes,
Right.
indeed, my lord.
Any reply, Mr. Adamson? Ms. Nkabai?
Thank you, my lord. My learned colleague has argued that this is a case of new things.
Of?
New things. And that new things are happening in this case. Now, are those new things applicable in law? The community cannot come and give evidence. In this case, we're told that it's one person that is missing, and that person is Joshlin.
Ms. Nkabai?
Community-
Ms. Nkabai, it's a submission on a legal point, and whether the law should be developed to redefine, and that's a question that I have to consider, to elevate participation in sentence proceedings as an element to be taken into account.
My point exactly, my lord. The new things she's referring to is a community being the victims, the mother being the victim, the classmates being the victim. We've got one person, my lord, who disappeared, and that person is Joshlin, and that is the only person who can give version before this court.
I'll consider that submission in any event of how I deal with it. I've already indicated to an argument it might fall within the triad or the trits in Zin as it's been set out.
Regarding the second application,
No, it's not a separate application, it's just a submission made in argument. There's nothing new about it.
My lord, my learned colleague has made a request that our clients be registered.
It's in the indictment.
The point I want to make, yes, it is in the indictment, my lord. The point I want to make, will that be possible, even if the child in question hasn't given version?
It's in the indictment. I'll exercise my discretion about it.
As the court pleases, my lord.
Thank you. Tomorrow morning, what time do you want to start? What time do you want to start tomorrow? I envisage, I have not written down anything yet. I'm going to collect my thoughts and just have a few rough notes, and I'll give an extempore tomorrow. So I also anticipate rather, that there might be a lot of people arriving for the sentencing tomorrow. Does anybody know what the weather is going to be like?
Cold and rainy, my lord.
So instead of then starting at 8:30, I'm going to start at 9 to give both the police and the public sufficient time that there's not that big a rush in the morning. I will then deal with the sentence and will the parties be ready to address me on applications for leave to appeal?
My Lord, Your Lordship indicated we should, then we will.
Yeah.
I will.
Good. No, I'll be ready to hear you. Then we can finalize that. And hopefully be done by 2 roundabout. There will be some admin to be done. Do we have all the exhibits? Do we have all our exhibits? There's nothing with them. Right, I've just checked that nobody has removed any of the exhibits from my exhibit file because it must be secured. It will all have to go back to Cape Town tomorrow. It will be up to and I'm speaking to the families of the 3 individuals. It will be up to the South African Police Services, once I'm done, to determine the movement of the accused, who will then be sentenced individuals. I know that often, if it's doable, they will allow the family to speak to the individuals. I cannot make that ruling because I don't know what the logistics are, and I don't know what's going to be put in place. I also anticipate speaking to Mr. Van Ryn, Mr. Pollis and Ms. Smith, that you will in all probability not go back to the places where you were held, where you're going to be held tonight. So bring your things along. You will in all probability be transferred to a maximum security prison, which might or might not be Paulsmoor. I don't know. I will be informed in the morning. But you will not go back to Langebaan and you will not go back to Malmesbury, because irrespective of whether I impose life or less, it will be a maximum sentence, and you will be transported to a maximum correctional facility, and that will in all probability happen tomorrow, once I'm done. Thank you. The court will adjourn. I'll see you at 9 o'clock in the morning.